May I please the lordship? Considering item number 50 supplementary list, my lord, we have filed an additional affidavit, my lord, that may be called for, my lord. Obliged, my lord.
I beg to mention for listing one matter, my lord, television matter. And next week, my lord, any date.
May I beg, my lord, I beg to mention item number 33, my lord, of today's list, my lord. And I pray for application of the matter, my lord. Last time, 6-7 occasions the matter came in the list, but unfortunately it did not reach, my lord. Otherwise, the case is ready, my lord. Other side has also filed affidavit.
Okay, 2.
My lord, obliged, my lord.
May I please your lordship? I beg to mention a WPC for listing in orders.
16th.
Obliged.
My lord, this is a contempt petition, my lord, pending since 2020, my lord.
21st.
May I please your lordship? Actually, I beg to mention item number 8 of today's discussion. She has submitted an adjournment request yesterday, lordship.
After view vacation.
Lordship.
Maybe.
Obliged.
Maybe, lordship. Lordship, I beg to mention item number 22, lordship. Here I am the petitioner of now in the IL lordship and respondent lordship. Yesterday I filed affidavit of opposition in IL lordship. Lordship, I want to lordship that maybe take up lordship, but the applicant lordship, they have objection lordship. If otherwise they have said lordship, I will take the possible lordship, but they have objection lordship. That so maybe others may be taken out the 2 family lordship. In the first of lordship, other cases lordship. Others the issue is that my appeal should be.
Second half. Yes.
My lord, item number 55, my lord. We have filed an additional affidavit, which is not on record. It will be called for, my lord.
May I please, your lordship? I beg to mention for item 47, my lord. With the consent from the other side, the matter may be kindly adjourned for the day, your lordship. Item number 47.
The priority counsel for the petition matter for its expertise.
Hi, lord.
May I please, your lordship? I beg to mention one listing of a contempt case for order.
21st.
Obliged.
This is a personal opinion.
Where are they?
Secretary here, lordship. And in fact, we have prepared the affidavit, lordship.
Item number 24 and item number 54.
What's your good name?
Narayan.
See, we have just asked you to be here for the reason is that otherwise there is no such contempt or anything against you at this moment before us. But what we found is that in the numbers of cases, the education department failed to place the relevant instructions. You have a battery of standing counsels. First of all, we see very few in the court. Secondly, we found that most of the cases, if it is 100 cases, then you will see out of 95 cases, they will try to take time. And it's really disturbing in the matter and also obstructing in the adjudicating the matters. So, are we aware, as being the secretary of the, you are representing all the 3 departments?
Yes.
Including higher.
Yes. Lordship, he has
Are
done
we-
last month.
So see, basically, will be required to reply in all these matters. Before filing any such affidavit, number one, secondly, what we found that it is the directors they are filing the affidavits. In most of the cases, it is the decision of the government. Whether it is a cases of compassionate appointment or whatever. If it goes to state level committee, then it is always the secretary who is supposed to place it. Again, the burden goes to you. We don't get the informations, right? Every time the council appears, they seek time. And this way it cannot continue for long. It's not helping anyone as such. And if you see the matters 2017 and 2016, notices to be issued, stay orders are in force. All these lawyers are aware. So these are the things what we found. That is why we need to clarify before you, since you are heading the department. And it's just, you need, it should be firm enough with your other departmental authorities. It will take shape. because I also worked in the other side, the same represented the same department. We knew how is to do it. So what we want is that you should take stock about it. Now, if you ask and go back to your departments, all the three, if you ask them how many cases is districts you have, I'm sure they will not be able to reply. And most of the cases, what we found, are already decided by this court, either by the judgments of Justice Gogoi, Justice Amita Roy, Justice Rishikesh Roy, Justice B.K. Sharma, Justice B.P. Kotuki, Justice Sika. Most of the cases are settled. This way, the activity issues are settled. Sometimes the new act comes in or other things, that's a difference. But otherwise, most of the cases are settled. Now, we have in cases today in our hand, what we found. We have made it part only to place it before you. It's a Balika ME school. How do you see, you are the authority, you want to provincialize because you want to secure somebody's service. But what we found, the government is not at all concerned about the students. It's a Balika ME school. That means it starts from class 6, 7. That you know, that's the age where a girl attains a puberty. There is no toilet. It is the report of the DICE, right? In spite of that, no boundary wall, no toilet, nothing, and you have provincialized the service of the teachers. So basically, you want to help the students to get their education, or you want that you should earn something. Only the teachers should be provincialized without being considered for the students. Just wondering how come you can think about this. You are the government. There is a specific judgment from the High Court passed by Justice Gogoi as he was then. There should not be any political interference in the management and administration of the educational institutions. It was a case of higher education, probably from the Nagorbera side, if I have rightly remembered. Then it was in higher education, probably one Dilwar Hussain was the director of higher education at that point of time. A specific order was passed, though the matter relates to a higher education, a governing body of a college. In that particular judgment, it was clarified that there shall not be any interference, any political interference in the management and administration of the educational institutions. But what we found when the note was given to the departmental minister, Mr. Sisti is aware about it.
Yes.
When the matter was placed before the, because constitution of the SMDCs in high school or higher secondary schools, earlier it was the director of secondary education who used to require approval to be given after the approval from the government. To cut it that short process, so it was said that the commissioner should be, the deputy commissioner should be empowered to give such approval. Now, the proposal was given by the commissioner to the departmental minister, right? But what the departmental minister has done, added that it should be go through the guardian minister.
Yes.
Again, political interference. You'll be surprised how many cases every day it is listed with the constitution of the SMDCs because of the departmental minister in each district. They want their men to be the president, secretary, president and vice president. Sorry, secretary is the headmaster or the principal. So that's how the number of cases are increasing. But when there is a specific order from the High Court, there shall not be any interference of the political persons therein. These things are happening. Okay. And the very surprisingly, say in a particular college, with regard to filling up of a post of assistant professor, if the posts are advertised in court passed an order, stay order, or not to fill up that post without the leave of the court, what kind of, some kind of restraining the authorities to filling up that post? Passed in 2016 and continued till date. By not appointing an assistant professor in a college, you can understand what is happening in that college. The students studying there are deprived of full-fledged faculties. That is the reason we want you here and should discuss these issues with your standing councils. And if you ask us what we found yesterday, it is not the final one. Till yesterday, matters pending for adjudication in elementary is 1,160. But the secondary, 880. And in higher education, 470, where there is in all these matters, no affidavits. In most of the cases, stay orders are in force. Leaving aside all recent cases to 2020, 22 and 23, we have not taken 2022 and 23 in consideration. So up to 2021, this is the stage where there is no affidavits. So how will you know? The court will know the stand of the government. So you should think about, and you should, if you want to do good work, you can do. That we have seen earlier.
In fact, we had a meeting yesterday, Lordship, regarding all these issues, Lordship, with the Honorable Minister in the presence of Secretary also, Lordship, with the standing council. And we are going to formulate all these things, Lordship.
And this is one particular department having numbers of highest number of cases in the High Court and large number of standing councils. Unless you look into it, Mr. Secretary, it will be difficult. And see, from morning till evening, if you don't get the assistance, if there is no affidavits, how the standing councils will argue their matter. And one more thing, when you ask the authorities to send parawise comment, ask them to use their judicial brain, at least some kind of mind they are in. They will send no comment, no comment, no comment, and 2 lines in favor of the petitioner or favor of the respondent, but without any reasons. There has to be some valid reasons in supporting somebody's case. That is why in most of the cases we found that the affidavits do file in the name of the director, they are incomplete. Right? So you can understand. These are the reasons we wanted you here, and henceforth we'll give you some more time up to April. Thereafter, if you see that the department is not changing, some other things we should have in our mind now, right? But we're very surprised over one more thing, how you have provincialized those teachers in girls' ME school or girls' high school where there is no toilet, nothing. How is it possible?
Toilet 0, 0, 0, 0. Boys 0, girls 0. It is school information schedule. Toilet not.
How they, in spite of these reports of the DICE or NUPA, whatever you say, why you have provincialized? Why you have provincialized? Now you cannot deprovincialize. Once you have provincialized, so you can understand how your department works, right? Mr. Sisti,
Yes, Your Lordship.
do you have any such officer which you who can help the standing councils to get the information? Any kind of liaison officer or anyone?
Nodal officers, nodal officers.
He looks after all the 3 departments or only one?
For each department, there are separate nodal officers.
Each department there is separate nodal
For
officers.
elementary, there is one officer. For secondary, there is one officer at the secretariat. And for higher also, there is one nodal officer.
Only thing they have been new, also they are also Lordship learning Lordship to cope with this question, Lordship.
Do you have the list of provincialized schools with you? District wise,
Yes, ma'am.
treasury wise?
Yes, ma'am.
Treasury wise.
Treasury level director.
How many teachers you have in elementary schools? Provincialized elementary, throughout state of Assam?
Madam, exactly right now, I don't have the.
Roughly?
But probably, roughly it will be around 2 to 3 lakh.
2 to 3 lakhs. Assistant teachers in elementary schools. What is the burden of the public?
Burden in the sense.
Giving their salary?
Salary,
Salary burden, it will be around 10,000 crore.
10,000 crore per month,
Not the exact,
roughly,
it's per month.
not for per annum.
per annum. Okay. Now, one more thing we want to know from you. You have brought into force the 2017 Act, provincializing service. You have kept a provision. You have provincialized numbers of tutors, whether it is in LP school, ME school, high school, higher secondary school, and colleges. And you have allowed them to attain their eligibility within 5 years. But at whose cost? At the cost of the public. You are paying them salary and asking them to attain their eligibility within 5 years. Why at the public cost? Can you tell us why? That means somebody will study in some college, some high school, somewhere, will attain his BA degree or attain BA degree, will acquire MA degree or NET, SLET, whatever, at the cost of the public.
If I'm not wrong, I think they are allowed for distance only.
Mr. Sisti, show him the provision. Is it possible? Why the government is so benevolent at the public exeter? Those particular teachers who doesn't have the eligibility, you have provincialized them in a fixed pay of real, but asking them to attain their eligibility at the public cost. Why? Mr. Mahanta, these things have been raising from some time, but I found that lawyers from the bar may be losing up their cases or their clients. They are not coming up. On many occasions, Mr. Bhuya, who is to always very aggressive, is to tell him, even he is silent. How can it be possible? I was wondering, how can in an act, there is maybe a provision that somebody to acquire eligibility, it is from the public exchequer, he will be asked to attain the eligibility. It is up to the level of higher education, not from the LP teacher, from LP teacher to higher education. That's the act. And nobody is being enter public from the state of Assam. Nobody is raising an issue. Very surprising. Asking somebody to attain their eligibility at the public cost, getting government salary. You may be new, may not be aware of all this, but these things are happening. That is why I am bringing it to your notice. These are the things we found that education department never bothered to look into it. Girls' school, high school, ME school, whatever, the colleges doesn't have the facilities of drinking water, no toilet, but you are provincializing the services. So at least you should have a team of your own in the government to decide all these things. And remember, what we found, it is the director who is filing affidavit this way, that way, whatever way, right? But when there is in most of the cases, it's the role of the government. And the government cannot keep silent without filing an affidavit. Director is not the government. And while going back to your office, ask all of them what are the judgments passed earlier by the Honorable High Court at Guwahati here. What are the orders passed? Ask them to, because all these orders are available. They may not be brought to your notice or your knowledge for some vested interest, right? But these are all available with your office. Ask them to find out how many cases are pending in each district. Because you have district-wise people, district-wise tables are there before you. Ask them to find out. Find out in how many cases affidavits have been filed. What is the stand of the government? It will take some time, but if you start working now onwards, definitely you will be able to do it. It was done earlier, but you need the will to do it. That's all. Now just tell us, being the Secretary of the Department of Education, when can we expect good results? On the month of May?
Yesterday we had the first exercise. In its yesterday discussions, we are planning to develop a portal where there will be kind of constant interaction between our standing council and the department officials. So that is the suggestion given by the standing council. Honorable ministers also accepted it. So after that, my lord, we are going to have at least one sitting in a month, so that we can have a review kind of thing, whatever problems faced by the standing councils and whatever support required from the department, that sort of coordinations. At least once in a month, we are going to sit, my lord. So I think it will take another, because numbers of cases are very high.
We are finding cases of fine computer,
Yeah.
we will sort out everything.
So that way, it will take another 6 months, my lord.
Don't say 6 months.
6 months will be too early. 6 months day over. We have to do it early.
But
Do you want to close down this high court for the 6 months?
No,
To
madam,
wait
no.
till your affidavits or your
No, madam,
instructions?
nothing like that. We are going to have a prioritized cases. So based on that, so action will be started, but finally to have a kind of whatever response you are expecting. So it might take little time because the numbers of cases are very high.
That's why I'm telling you, most of the issues are settled. Accepting the new act, any such issues regarding the new act, most of the cases are settled.
But we have started working on it. So yesterday we had a first discussion. So yesterday we tried to find out the issues.
Do you have the records, authenticated records of the schools, provincialized schools or the government schools, and the teachers and the other non-teaching staff serving there against which particular post? Do you think that there are access teachers in every school?
Might be in some cases, some specific cases. Because rationalization exercise, my lord, is happening at a district level. So the entire purpose of the rationalization exercise is to be.
Even after the process of rationalization, do you think there are access teachers? Even after the process of rationalization in terms of the division bench judgment, suo motu matter, do you think there are access teachers?
Access teacher,
Not in the pupil teacher ratio that we always know, since you have lakhs of teachers. Definitely in some cases, pupil teacher ratios will be very high and it will be somewhere it is cannot be compared with, right? In my village, I have seen many such schools because you have clubbed together 4 or 5 schools,
Yes.
closing down some of the schools. In those schools, students are hardly 30 and teachers are more than 10 or 12. What we have noticed is that there is no place for the teachers to sit. There is no common room or something, even if there are no chairs, right? So the teachers among themselves have phased out, selected a time like frame. You'll come on Monday, you'll come on Tuesday, you'll come Thursday, or you will stay on this period, you'll come back in the second half, you'll come in the first half. That is the system. Otherwise, they have no place to sit in the particular school campus itself. How are you going to manage all this? You have closed down those schools, no doubt, because of no students. You have clubbed them along with one of the neighbor schools. How will you manage? And what you have done with those public property, which you have closed down? Because we have seen those schools which have been closed down. Their goats are available, cows are available, cow dungs are available, everything is available. But all are public property. You have not converted those schools to a particular center or for a library for the students or whatever. You could have easily, these are all structures, permanent structures are there. That's lying at no policies, nothing for those.
My lord, one policy will come out this year. That is what we are planning for opening up IIT by the private players. So government is, in fact, we have a review meeting with the skill department. So in that skill department is proposing of promoting the private players to opening up IIT, ITI, sorry. So in that case, what we are planning from a school education department side, if any private player is coming up for opening up IIT or kind of institute, ITI kind of institute, then the school building, which was marked and now it's vacant. So from our side, we are ready to provide that building, at least for the private player, it will be an incentive that he will get a ready-made structure. So for infrastructure part, his cost will be reduced. That is one, we had a meeting, both the minister and honorable minister, they had a meeting. So that kind of policy level thinking is going on. So in some places, even then in certain rural areas, obviously nobody will go there. For that, obviously you have to have some policy decisions how to utilize those infrastructure. But in some places, this is the thinking of the government mind. So at least some utilization will be happening for those abandoned infrastructure if somebody's come for opening ITI.
One of your colleagues, who is my classmate, was looking after Guwahati ITI. Told me he, of his own, he brought in some technicians from the Samsung company from Korea, along with the interpreter, because they speak in Korean language. Applications were invited to have the training from the original Samsung company, so that the fridge, refrigerators and all the AC machines all can be repaired.
Appliances.
Here's Mr. Rituraj Bora. Ask him who got the benefit. He will let you know. Ask him who got the benefit. The schemes of the governments are there, but who takes that benefit? It was widely published, and you are surprised to see in 2 phases he tried, thereafter he closed it down. There are obvious reasons. Right. So unless you prepare the students at the elementary, at the upper primary, and as well as the secondary levels, how will you go for those trainings? Teachers are fighting to have the post of in-charge principal, in-charge headmaster, not bothered to have to take classes. Right? The second issue is what we found. Not only second, there are numbers of issues. Is that Chief Secretary of the state in a particular matter sworn an affidavit saying that 6 months prior to the date of retirement, the concerned incumbent, the government employee will be made known his date of retirement. And he will be asked to submit all the relevant documents so that within a month he gets his pension. Is it happening?
My lord, yesterday I had a review meeting. It appears from the review.
One of my
meeting-
brother is regularly taking up pension matters, and we find out how many numbers
Yes,
of
yes,
education
my lord.
department
Yesterday,
cases in
this
pension
issue was raised by standing councils that these cases are coming because honorable ministers wanted to know what type of cases are coming in our respected court. Then this is one issue. This was one of the issues raised by honorable standing councils in yesterday's meeting. So in fact, then honorable ministers had given me the instruction to streamline these cases. So we'll take up. But
Why?
it appears
Because we
from
found it is the non-teaching staff who are grade 4, grade 3. It's not happening with any headmaster. It's not happening with any principal. It's happening with some assistant teachers and non-teaching staff of a school. Why it's happening? And it is very common. You ask anybody, you pay, you get your pension. The Borobabus of the schools, they are managing. You ask anywhere. You go anywhere, you inquire, they will let you know what is happening. Why these people are not getting their pensions? Why numbers of pension cases? Okay, today is 10th of March. By 26th of April, will give us the details district-wise. The number of educational institutes, provincialized education institutes, and the government education institutes. And the teachers serving the post sanction against each post, teachers serving and non-teaching staff serving, their names. Give us in both in electronic format as well as booklet format. And along with that booklet, one such booklet was prepared by the Directorate of Higher Education at the time of provincialization of the colleges, along with the names of the incumbent who was serving in which department and the post in which they are going to be provincialized, because it was earlier grants in 8 colleges. So the posts that were being created for them, I don't know whether booklets are available, follow that system and it is district wise and category wise in the particular treasury. Particular schools goes to a particular treasury. There are many sub treasuries in a district. So give us those lists, school wise, category wise for higher education, for upper primary, middle, elementary, secondary level, middle level, as well as lower primary. There was a case here for your information. A lady from Borak Valley was not promoted to the post of headmistress in an upper primary school. The court passed an order. So director of elementary education appointed her as promoted her as a headmistress. She went to join that school, but the school doesn't exist. It's a provincialized school. Somebody were getting their salaries. She went back. She went to that school to join the post as a headmistress of that upper primary schools, and found that school is not existent. She came back and filed another case. Of course, informed the government in that case. Then she was allotted another school. She went there. It's a recorded case here in the Guwahati High Court. The order was initially passed by Justice P.G. Agarwal. Then there was the second school. She went there in Borak Valley. It's in somewhere in the 3 districts. I forgot the exact district. Even that school doesn't exist. It exists in paper, it exists in treasury officer, but physically it doesn't exist. No students now. She again approached the government. Government didn't do anything. She preferred a file a writ petition, and contempt petition was filed. By the time it was processed, she retired from service. What government has done? She was given the pay scale of a headmistress in the upper primary school, so that she gets higher pension. But the third school in which she was placed as a promoted as a headmistress and posted as such, even that third school did not exist. It's a recorded judgment in the High Court. How many such non-existent schools you have? Will you be able to tell us? Mr. Secretary, do you know what happened? There are schemes to provide computers and everything to the schools. Schools are not willing to take those computers, those benefits. The reasons, 2 reasons I was told earlier. One is the school is non-existent. Secondly, schools doesn't have a proper building to keep all these computers and others. Doesn't have a Godrej like system in lockery or something to keep these things in safe custody. Right? Even then, our children are educated in that manner. Do you think our children are able to compete in other parts of the states?
Yet computer 90.
So give us this information within a month's time. 26th of April, you have given your time. And Mr. Sisti, you have some good standing counsels who are competent, much competent, definitely I must admit. But not all, but they have a scope to develop themselves. But your instruction must reach the court at right time. Go back and think over, talk with your officers, how to do it. Otherwise, from the month of May, the court will have a different sort of ideas. Mr. Sisti?
Yes, sir.
You have to take lots of burden now.
Yes.
Give us these information in booklets as well as in electronic form,
Yes.
so that it can help the council.
Yes, sir.
Mr. Bhuya will pass the order later on. Person to the order. The discussion. the Secretary, Department of School Education, as well as Department of Higher Education, Research and such. Personal present before the court.
School data আপনার 89 ভাবে connected নিউজ and information
The court explained to him as to how to do non-filing of such affidavits and oblique or not placing the relevant instructions in the matter. How the respondent education departments are obstructing the court in adjudicating the matters. Mr. Secretary submitted that assured that things will improve. Based on 26
one to run like
04/2023. And they said that the Department of Education, School Urinbakat Elementary, as well as the Department of Higher Education, shall give the details of provincialized / government lower primary, upper primary, secondary and higher secondary schools, district wise, block wise, of the district concerned, along with the respective treasury and the posts sanctioned in each of such educational institutions, and the name of the incumbents against such posts serving in those institutions, both in a booklet form as well as in electronic. Until further order of the court, personal appearance of such and such is dispensed with. Okay, can you furnish a copy of this one? Mr. Sisti, ask him, tell him what are the difficulties. We have highlighted few issues you can always discuss and ask the authorities of you who were there in your office to find out all the old orders. Most of the issues are settled, that much you can do. Okay. You can leave now. Item 24 and 54 will pass separate orders.
In this case, my lord, petitioner, my lord, she has applied for, my lord, relaxation of the upper age, my lord. 2 times state, my lord, Hindi qualified, my lord. And numbers of posts are, my lord, vacant, my lord. Just, my lord, in view of the 51 notification, her, my lord, representation may be considered, my lord. It is
Hardly, sorry, it's just counsel appearing for the petitioner.
allowed to submit her candidature. 3/5/1951 my lord. Notification, my lord.
Read your prayers, read your prayers,
Lordship,
read your prayers.
prayed that your Lordship may please to admit the petition call for your issue rule calling upon the response to so why the manner shall not be issued to direct respondent, more particular director of secondary education Assam to allow her to submit on offline mode, submit a form on offline mode and thereafter by adding 50 marks for her experience. She is now she is also working in the contractual school. Kasturba Gandhi Balika Vidyalaya along with her TET and general qualification marks consider her in the merit list by condoning the age of 1 year 1 month more than 43 years of upper age limit on 1/1/22 for her verification and recruitment as graduate teacher in the defined higher secondary arts Hindi school of Assam as an aged candidate. That is my prayer.
Are you aware of the recent judgments of the Honorable Apex Court? Mr. Das,
Lordship.
whether the court has any such power under Article 226 to change the structure of the advertisement?
No,
the
no,
requirement
no,
of
no, madam.
advertisement,
Only for a consideration of a relaxation of the age. My prayer is.
whether court can do it.
Her madam, in view of the
Who is the
notification.
authority to relax your age?
Lordship.
Who is the authority to relax your age?
Government is the.
Then
madam,
the
that is.
application is pending. At best, we can send it the government.
Yes,
to take
yes.
care.
If it is maintainable, it may be considered, and it is not, then it may be rejected. In view of this, my lord, I have that, my lord, this notification, my lord says that, my lord, relevant portion in this judgment, my lord. Notwithstanding anything to the contrary in rules regulating the maximum or minimum age of recruitment to service or post in the connection with the affairs of the state of Assam, the age limit may be relaxed in favor of any candidate or class of candidates only. In case in which the appointing authority is the governor, in other cases, the head of the department considers the necessary in the interest of fair dealing or in the public interest. So my prayer is not on merit, my lord, even just to consider it, my lord. If it is rejected, rejected.
Not
my lord.
Mr. It's just counsel appearing for the petition. Mr. Ezi, are you appearing?
Actually, there is a confusion, but I am appearing. I was appearing, supposed to be appearing in another case.
Okay. It doesn't matter.
Anyway, I am appearing. And
Mr.
also, he said the direction to
Authority is-
consider her representative as per law.
Law.
In force.
Mr. D. Seki, Current Advocate General Assam, assisted by Mr. SMT Sisti for the respondent numbers 1 to 4. The Director of Secondary Education Assam on 28/12/2022 issued an advertisement for filling up of 7500 vacant post of assistant teachers in science, arts, Hindi and Sanskrit in different provincialized schools of the districts of Assam. Petitioner has a requisite eligibility for consideration for the post of Hindi teacher in such secondary schools. However, she has crossed the upper age limit for filing such applications for the post of into any government post. By filing an additional affidavit, the petitioner have placed before the court that on 12/01/2023, So he has filed an application before the Secretary Government of Assam in the Department of School Education to consider to condone her upper age, enabling her to apply for the post so advertised on such and such date prior. And that said application of the petitioner condoning her overage is yet to be considered. Mr. Das, Learned Counsel for the petitioner, placed that the state government by notification number AAP.34/50/27 03/05/1951, General Administrative Department provided that one and two side over there, such and such. Considering the above, the respondent number 1, Secretary Government of Assam in the Department of School Education, is directed to dispose of the representation of the petitioner within a period of 15 days from the date of submission of certified copy of this order, and to decide on the issue of condoning the upper age of the petitioner in accordance with law and the said notification dated 03/05/1951 noted above. In the event of any such condonation of her upper age, the petitioner may approach the authority concerned for acceptance of her application for the post of Hindi teacher as advertised on such and such. Since the last date of it has been issued, I think so, very few days back. The last date has been
28 online.
Okay, we will not say anything on. We will not say anything on that. This was a census intimating the petitioner about the outcome of her said representation. The petitioner shall submit a certified copy of this order along with a copy of her representation dated 12/01/2023 before the Secretary, Department of School Education, forthwith obtaining necessary acknowledgement from him in that regard.
I will explain. KDB, Mrs. KDB will request to take time. It may be pass over. She is in another court.
Mr. Pego, we're supposed to have the SLC decision. Do you have the instruction? Okay, we'll have it on 27th. Placed on 27th, enabling and Government Advocate Assam MSD does government to place the relevant instructions regarding the decision of the SLC State Level Committee for Compassionate Appointment in its meeting held on 25/06/2015.
Next is your lordship. My lord,
জেরক্স করে বলুন না কিছু।
Heard Mr. Dinesh Worthing, counsel appearing for the petition. And Ms. Didas Bowman, Government Advocate Assam, for the response number 1. One and response number 2. Also heard Study Council, Department of School Education, for the response number 2, 3, and 5. Matter pertains to compassionate appointment under the Design Harness Scheme. Mother of the petitioner, Kiran Mala Devi, an assistant teacher at Pangram ME School, the Udargont Education Block of District Kachar, died in harness on 22/07/2010, leaving behind her husband and 2 sons, including the petitioner. Petitioner applied for his compassionate appointment. Pursuant to the orders of the court, the district level committee for compassionate appointment, District Kachar, Kachar district, recommended the name of the petitioner. Ms. Borman Government Advocate Assam has placed a copy of the minute dated 22/01/2022 of the state level committee for compassionate appointment, in which the case of the petitioner was considered, and the said SLC found that the petitioner applied for his compassionate appointment after more than 1 year from the date of the deceased, and as such rejected his claim for such compassionate appointment. In view of the above, as the case of the petitioner for his compassionate appointment after due consideration rejected by the state level committee for compassionate appointment, this petition being in a dividend merit stands dismissed. Needless to say, petitioner is always at liberty to challenge any such decision of the SLC.
My lord, in this
Yes, yes.
in this writ petition, lordship, I make already challenge, lordship, although the
This
minor.
is a 7.
Because lordship, on 33/2011, I make my application, lordship, which is already, lordship, mentioned in the initial DLC minutes of 28/5/2013, lordship.
Pursuant to the order letter, this doesn't place the minutes of the SLC dated 22/01/2022 before the court, rejecting the case of the petitioner for its compassionate appointment. The respondent numbers 1 and 2 shall file their respective affidavits. Respondent number 2 declare, secretary, the secretary of the state level committee for compassionate appointment, shall file its detailed affidavit in the matter, annexing the copy of the application of the petitioner on which he submitted his application for compassionate appointment. Notice have not been issued.
Notice not issued.
Issue notice returnable to 8 weeks as such a no permanent notice. Response number 1 good. Response number 2 such and such self filing. So as our date of application is date of birth.
Hello.
Yes, Mr. Sharma.
May please your lordship. My lord, this petition relating to non-payment of medical bills, lordships. Lordship, this ex post facto approval was accorded by the referral medical board lordships of Guwahati Medical College Hospital, and lordships, the authority is of the view that it is time bound. But already the petitioner has submitted the bills, medical bills of 471 in 2010.
Who is for the
lords.
respondent departments? Health and family. Are you in health nowadays? Someone said you have resigned from the health. You have resigned from higher education. When did you approve the approval from the finance?
Lordships, page 34, dated 28/7/2017. Referral medical certificate.
Then
Lordships, thereafter, page 35, lordships, this, it was resubmitted for view and comments by undersecretary to the joint secretary, lordships. That is page 35, lordships. And thereafter, lordships, page 36, undersecretary to the director, and the proposal is.
what is that office memorandum, Mr. Chalina?
That is not next. The office memorandum dated on the basis of which the name of the petitioner said that it's time part of it. Lordship, page 36, lecture 9, it is mentioned the period of claim for medical reimbursement respect for so wife of so appears to be time barred, and then there is a specific period given mentioned by 24.
Now, that's what we want to know from you, Mr. Saleh, that the office memorandum of 25th of October 2019 came into force from that date or giving a retrospective effect.
That we have to
But definitely the petitioner's application was much prior to that,
yes, sir.
because from the communication that you have can see here is that is 35. Is 35. They submitted on 22nd of October 2018. Original proposal was of 22nd of October 2018. Right? And then see, the man expired on 10/5/2011. And the referral certificate was issued in July 2017. Page number 34. This is an ex post facto approval. So this was given on 28th of July 2017. And thereafter, petitioner might have applied for. And that proposal was, as you can see from page number 35, it was of 22nd of October 2018. That office memorandum came into force only from 25th of October 2019.
From the record, from the record at the moment, we can see whether it has a retroactive.
Get it and tell us
Yes, sir.
what Mr. Raj Sharma, counsel appearing for the petition. Also heard Mr. GPFO, Standing Council, Department of School Education, for the response number 134, and Mr. H. Aliha, Standing Council, Finance, as well as Health Department of State, for the response numbers 2 and 5. Husband of the petitioner. No, husband. Wife of the petitioner, Kansan Deka, assistant teacher of Bijulibari High School, Marui. Sipaza, District Darang. Died on died on 10/05/2011. Due to kidney disease. The petitioner obtained ex post facto approval towards treatment and investigation of his wife from the superintendent of Guwahati Medical College Hospital on 28/07/2017. Thereafter, he applied for medical reimbursement in respect of his late wife, Kansan Deka. The proposal for such medical reimbursement claim of said late Kansan Deka was forwarded by the Joint Director of Health Services, Dorong, on 22/10/2018. However, the said proposal of the petitioner was rejected pursuant to the office memorandum number HLA.1019/2017/148 dated 25/10/2019, specifying it to be a time barred. The said decision of the Health and Family Welfare Department rejecting the medical claim of the petitioner was communicated by the Director of Elementary Education Assam on 13/06/2022. Being agreed with such rejection, petitioner preferred this petition. Issue notice returnable by Patrick's as such and such, no formal notice. Petitioners are ready to the extra copies. So notice now issue really good. As such and such, no formal notice. Service of notice is completed. On the returnable date, the respondent number not filed.
Because the authority has not been made a party to the director of the service.
Sorry. the secretary for proper adjudication of this case. The joint secretary, the secretary government of Assam, the health and family welfare department, as well as the joint secretary government of Assam, the health and family department be included as party respondent numbers 6 and 7. Mr. Reservation, standing counsel Helen Atkins also appeared on behalf of newly included respondent number 6 and 7. Complete whatever that is correct. On the next date fixed, the secretary government of Assam in the health and family welfare department, respondent number 6, Sal, place a copy of the office memorandum number HLA.1019/2017/148 dated 25/10/2019, on the basis of which the medical claim of the petitioner was rejected by the respondent authorities. Mr. Sharma takes this.
Lordship.
Correct, because that-
The name of the health department may be reflected on the positive.
Yes, yes, where register shall reflect the name of standing council health and family welfare department for the respondent numbers 5 and 6.
Please, Your Lordship. This is related to regulation of service of the petition.
Where is your appointment on?
1 to 1986, Your Lordship.
Where is that?
Your Lordship will be my appointment. Page 23, Your Lordship.
When the school was provincialized? Number 575.
My lord, school
God
was
Peter,
provincialized, Your
when-
Lordship. But school was provincialized. Provincialization not mentioned, my lord, but school was provincialized as well as yeah, the school was amalgamated with the Gorbitor High School, Your Lordship. Your Lordship will find.
Heard Mr. M. Chaudhary, counsel appearing for the petition. And Mr. G. Peku, standing counsel, Department of School Education, will make it elementary for respondent numbers 1, 2, 3, 1, 2, and 3. Any standing council BTC and MS RB Bora, standing council BTC for the respondent numbers 4 to 7. The claim of the petitioner is that since last 35, the petitioner is serving at number 575 Gaur Vitor Muktab Lower Primary School, which is subsequently amalgamated with Gaur Vitor High School. Knees Thomthoma in the district of Baksa, BTAD. His service is yet to be regularized. Petitioner submitted that pursuant to the order dated 25/01/1986 issued by the president of the managing committee of Gorbitor 575 Gorbitor Muktab Lower Primary School, is serving as the third teacher in the said Lower Primary School honorary basis since 01/02/1986. On the next date fixed, the Director of Elementary Education Assam, response number 2, as well as the Director of Education BTC, response number 5, shall apprise the court as to when the number 575 Gaur Bhitor Muktab Lower Primary School.
Lordship, kindly see annexure 14, 15, and 16, Lordship. Already director has issued speaking order. He has talking in provincialized school, Lordship. Yeah, you are appointed by municipal committee in provincialized school, Lordship. Kindly see annexure 14 and speaking order annexure 16.
So when the Gaur Bhitor High School, such and such, LP school, amalgamated such and such, Nees Dhamdhama, district Baksa, earlier Nalbari, was provincialized. List on 30th of March. Give us the date on which that school was provincialized. LP school. Petitioners have served 2 extra copies to Mr. G. Peru, Government Extending Council, as well as MS Agriculture. By Monday. Mr. Pegu, just get the date by which order the school was provincialized.
May be your lordship. Lordship, in this case, lordship, petitioner's lordship claim for provincialization was not recommended by the state level scrutiny committee, lordship. And again, by page 72, lordship.
What is the recommendation of the district scrutiny committee?
Lordship, what happened, lordship, during there was a case, lordship, order of this honorable court, lordship, to consider the case of the petitioner, lordship. Thereafter, the order was not complied with. Page 67, the order of this honorable court, lordship. And there was a direction to consider the claim of the petitioner within 3 months, lordship. After 3 months, lordship, petitioner filed contempt, lordship. During the pendency of this contempt, lordship, the page 72 was issued by the director, lordship. Page 72, lordship, wherein it is written that lordship in the below, lordship. Here the recommendation is also mentioned that the state has recommended, lordship, and thereafter accordingly SSA Assam submitted the DICE verification report in which it is seen that the name of both the teachers have not appeared in the DICE data mentioned by the NEPUA, New Delhi, up to the year 1617 against Sipur Fulbari based on the DICE verification report. The SLSC as well as Joint Committee could not recommend that the above mentioned teachers against school, lordship. Against the order, lordship, the petitioner filed an appeal, lordship, before the lordship, say page 74, lordship. This is pending, lordship.
When did you file?
Lordship, page 74, lordship. Just filed on, lordship, 19/12/2022, lordship. 19/12/2022, lordship. It is pending, lordship, page 81, lordship, the status, lordship. Now it is pending before the.
Where is the receipt?
Lordship, page 81, lordship. page 81, Lordship, the details, Lordship, receipt number, the subject, an appeal against the order, location, receipt box, sender, Sultana Begum Lashkar, section, secretary, school education, send on the 19/12/2020, currently with Vijaya Chaudhary, Official Secretary, Lordship.
Okay. Heard Mr. AMS moving to council hearing for the petitioner. And Mr. GPQ Government Standing Council Department of School Education for the response numbers 1 and 2. And Mr. Idas Government for the sum for the response number 3. And Mr. B Gogo Standing Council SSA for the response number 4. Petitioner submitted that as an assistant teacher at Sirpur Fulbari Residential Lower Primary School.
LP school.
Then Daspara in the category education block of district Silchar while it was in a venture stage. Though the district scrutiny committee recommended their names for provincialization of their services under the provisions of Pura 2017 Act writing. But the state level committee for state level scrutiny rejected the claim of the petitioner for provincialization. As their names did not figure in the DICE data maintained by NEPUA New Delhi up to the year 2016-17. Said decision of the state level scrutiny committee was communicated to the petitioner by the director of elementary education Assam by communication dated 10/06/2022. Against such decision of the state level scrutiny committee, 2022 filed an appeal under section 14 of the same Pura 2017 Act. As the matter did not progress thereafter, the petitioner has preferred this petition. Section 14. After hearing the counsel for the parties and considering actual legal matter, this petition is disposed of at the motion stage itself, directing the Secretary Government of Assam in the Department of School Education, back at elementary, to dispose of the appeal. Petitioner submitted before him on 19/12/2022, which had arisen on after verifying all the relevant records and giving an opportunity of hearing to the petitioners if so required within a period of 60 days from the date of receipt of certified copy of this order to be submitted by the petition. The Secretary Government of Assam in the Department of School Education shall intimate the petitioners about the outcome of their state appeal. The petitioners will submit a certified copy of this order along with a copy of their appeal dated 19/12/2022 before the Secretary of the Department of School Education. on or before. Thirty-eight of 30/03/2022, obtaining necessary acknowledgement of the said authority. Okay, which stands this for?
Blind.
Madam, in this case, my lord, I am challenging on advertisement. That is at page 15, my lord. On the ground that it violates the provision of Assam Scheduled Caste and Scheduled Tribes Reservation Act, my lord. My lord, page 15, my lord, a post of library bearer has been advertised and showing the roster point to be 6, and this should be reserved for OBC and MOBC. My lord, the fact of the case is that earlier one, Vipul Chandra Das, although he was an SC, but he was appointed in an unreserved post, my lord. So, my lord, if he was in an unreserved post, my lord, that is post is unreserved. So, my lord, going by the my lord, this annexure, my lord, is given in the act, my lord. If it is roster point number 6 and initial appointment is unreserved, then the post should be SC. And my lord, if the
Where from you are reading?
my lord, Assam Scheduled Caste and Scheduled Tribe Reservation of Post Services Act.
Being to the town.
My lord, there is a in the
1983 rules.
yes, my lord. 1978 and my lord, after the end of the office memorandum appendix to annexure 2, it is given, my lord. Recruitment of all India basis by open competition, direct recruitment. Appendix to annexure.
Which
2.
appendix? Appendix number?
Annexure 2, it is given annexure 2. Annexure 2.
Annexure 2.
Yes, I might.
No. Same book. Oh, no, 81 rules should come. No? Appendix and details. What do you like to show from here?
My lord, here from the roster register, it is evident that the person, Vipul Chandra Das, who retired, my lord, although he belonged to SC, but he was appointed in an unreserved post, my lord. Had he been
Where from you are reading? Where is that from? Appendix to annexure 2.
Yes, my lord.
Or 3.
2, my lord, that is given as 2. Direct recruitment on all India basis by open competition. Model roster for cadre strength up to 13%.
Yes.
So, my lord, I have given a copy of the roster register that is obtained through RTI application in page number 18, my lord. My lord, here the name of Vipul Chandra Das, who actually retired, was in the roster point. It is shown that he was appointed in an unreserved post, although he belongs to SC. But he was appointed in unreserved post, my lord. Now, my lord, as per section 4 of this act, my lord,
provided that candidates belonging to scheduled caste and scheduled income who qualify for selection on merit should be included in the general list and not against reserve quota. Section 4 of this act, my lord. So, my lord, here, although he may have been a SC candidate, but he was appointed in an unreserved post. So, if we in the advertisement, it showed that roster point number is 6, my lord. Roster point number is 6. Then here, my lord, if roster point number 6, if we go by the annexer 2, then after unreserved, it becomes SC, my lord, not OBC. After had it been he had been appointed in a SC category post, then it would have been a OBC, my lord.
Section 4 of 70 Act, where it is? Doesn't say like that.
Well, section, I'm reading, my lord. Section 4, my lord, in the from the bottom portion, second paragraph, my lord. I'm reading the relevant portion, my lord. Provided further that candidates belonging to scheduled caste and scheduled tribes who qualify for selection on merit shall be included in the general list and not against reserve quota.
So according to you,
so here, my lord, this person Vipul Chandra Das, who retired in the month of December, and that post has been advertised now, was, although he belonged to SC category, my lord, but he was appointed in an unreserved post, my lord. So here they have advertised in the advertised, they have mentioned it should be roster point number 6. Roster point number 6. So roster point number 6, that after unreserved, it comes to SC, and after SC, it becomes OBC. If the roster point in the post in which Vipul Chandra Das would have been appointed was SC post, then it had been done to OBC, my lord. But now, as he was appointed in an unreserved post, so it should be SC according to roster point number 6, my lord. To my understanding, my lord. If I may be wrong, my lord.
because roster point number 6 has many SC, OBC, you are unreserved.
No, my lord. Here, initial recruitment. It is given as initial recruitment. Here, initial recruitment in roster point number 6 is given as unreserved.
Now,
Here,
where from you are saying that he was an initial?
my lord, in the roster point, my lord, in page number 18, which your lordship sees, my lord, finally peruse, my lord. In serial number 1, the name of Vipul Chandra Das appears, and roster point is shown as unreserved, my lord. Roster point is shown as unreserved.
Who is right?
Unreserved. And my lord, his category is SC. He may belong to SC. Now again in the second part, my lord, one Rudrakanta Nath is there. His roster point is OBC, and he's also from OBC. But here Vipul Chandra Das, who retired on 31/12/22, was appointed in an unreserved post, although he had been a SC.
Okay. Heard Mr. I. Chaudhary, counsel appearing for the petition. And Mr. A.R. Tofil, standing counsel higher education for the respondent numbers 1 and 2. Petitioner belongs to the reserve community. Reserve community of scheduled caste. And first higher secondary examination. Earlier, he temporarily served as library bearer in Roha College, Nagaon, since 17/9/2016 on contractual basis. Earlier, petitioner served on a consolidated fixed pay of ₹1,000 per month. It is agreed by the advertisement dated which date dated 17/9 to no. 08/02/2023 is issued by the principal cum secretary of Roha College, inviting applications for one post of library bearer that is reserved for OBC/MOBC category of applicants at roster point number 6. Petitioner submitted that on Vipul Sundar Das, library bearer of St. Roha College, retired from service on 31/12/2022 on attaining the age of superannuation at 60 years. And said Vipul Sundar Das do belong to the scheduled caste community, but because of his merit, he was appointed as a library bearer of St. Roha College, Roha District, Nagaon, against an unreserved post. Petitioner submitted. Then on the retirement of St. Vipul Sundar Das, the principal cum secretary of Roha College on such and such date issued the said advertisement for the loan post of library bearer. By placing the provisions of the second proviso of section 4 within bracket small a of the Assam Scheduled Caste and Scheduled Tribes within bracket Reservation of Post in Services bracket close Act 1978 submitted that the candidates belonging to Scheduled Caste and Scheduled Tribes who qualify for selection on merit shall be included in the general list and not against the reserve quota. And as such, petitioner submitted that we as the roster point number 6 on the retirement of said Vipul Sundar Das, comma, an SC candidate appointed against unreserved post on merit, comma, on a such retirement from the following the 100-point roster. Now, the said post shall be reserved for. Why you are saying SC?
Because in roster point number 6, initial appointment is, if your lordship sees, then it was unreserved. Then from unreserved, the first it becomes SC, my lord. After SC, it becomes OBC. So Vipul Sundar Das, as he was unreserved,
will now also go to the reserve category of scheduled caste and not on OBC. At this is for proper adjudication of this case, the Secretary to Government of Assam in WPTC Department of the State be implemented as party respondent number 4. This is Mr. Roy, right? R. Mr. Sisti, that Standing Council WPTC. Ardhor. Mr. Ardhor, Standing Council such and such has entered appearance during with such and such. Issue notice returnable by such and such. 8 weeks. No, I didn't read here. So notice returnable by. Third of April. As Mr. Such and such, no formal notice. On the next date fix. Mr. Dhar, please. This is a post of library bearer in Roha College, District Nagaon. The petitioner is serving in that particular college on a fixed pay of rupees 1,000. Now a post has fell vacant. The post is now under roster point 6. Now the advertisement was made for OBC and MOBC. Petitioner belongs to scheduled caste community. Now he is saying that the section 4A sub second proviso. The person who retired do belongs to SC, but on his merit he was appointed in a post of unreserved category. So according to the petitioner, since the person who belonged to SC was appointed against unreserved category on his merit, so this post should now go to the scheduled caste, not to the OBC. Now that clarification is required from you, because normally what happens, the permission has been granted to the college authorities to issue that advertisement. As you know that the permission is required from the Director of Higher Education, who looks into all these aspects of the reserved categories and all. So probably the Director of Higher Education giving the approval for filling up of this post by the candidates from OBC and OBC category, following that roster number 6. So we want your assistance, clarify this one. And Mr. Tavildar, from the records, you also verify that because Director of Higher Education might have given the permission for advertisement of issued against OBC or MOBC. There definitely it will be there, because since the other person who retired belongs to SC, whether he was appointed on the basis of his merit against the unreserved category, because the annexer, last annexer shows he was posted against unreserved category. So whether he was posted unreserved category or adjusted, we do not know. Verify from the records and tell us. Third of April. They're fixing it on 3rd of April. Okay. This shall reflect in name of Mr. R. or Sending Council WPT basis for the rest number 5 of the court. Where is the last date?
Date has been not fixed for interview, my lord. We have mentioned in para 15 that they have yet to carry out the interview.
You have not filled up your application.
No, we have said that we have not been allowed to file our application. We, in the petition itself, we have mentioned as I am from SC, because according to the post, it is a OBC. In para 5, I have mentioned, my lord.
The list submitted by the petition that the petitioner intended to apply for the said post, but as it been reserved for OBC, his application was not considered by the college. Next, until further order will be put. Until such clarification that after the retirement of Said Vipul Chandra Das, library bearer from Roha College on 31/12/2022, whether the roster point at number 6 will be filled up by SC candidate or by OBC or MOBC candidate as advertised. The respondent authorities in the higher education department, including the Roha College, shall not proceed with the selection of the post of library as advertised on such and such. Just let us know to that extent, Mr. Tavildar, Mr. Thor, to that extent. Yes, Mr. Doctor.
I'm coming against cancellation of studentship on the ground of
failure to produce mark sheet of the qualifying degree. Lordship will find the email that was sent to me, page 46, Lordship. It was communicated to me on 2nd day of January, Lordship.
When was the last date you were supposed to submit your?
Initially, it was, what you will find at page 33. Before last, first, beside, beside you may also note the following. Before, thereafter, that's second, if your qualifying degree results are awaited, you shall have to produce the original certificate and mark sheet of each semester 31st/8/2020. Thereafter, since my result was not declared, I have submitted an application before the last date. That is
Mr. Director Council appearing for the petition. And
There's a big question in this case.
yes,
That's the only ground. That is not the only ground. Petitioners put wrongly stated in his petition. He doesn't possess the qualifying criteria, which is
that
given
is-
in the website.
that is not a ground for cancellation of my students.
file your affidavit, no problem. We're not
Or
upset.
you can file an appeal to the authority Lordship for considering the case. That is the case. That option is open without obtaining, availing that. Yes, state will come to this government.
Such provisions are there.
Yes, it's always considered. He has never approached the authority.
Give it to us such provision. Otherwise, unless the books we have, the IIT books. Nothing.
Or Lordship, notice be issued in this case. We file an affidavit stating everything.
Mr. Kakoti, give us that your booklet. It will be easier for us to find out the
I'll
provisions.
provide. But at
That
this
will
stage,
be-
at this stage, notice will be issued.
That's what we want.
Will-
And Mr. R.P. Kakoti, done at senior counsel, assisted by Mr. That's one number 22. 227. No, 225. Any CGC here? Oh, Mr. Yeah, Mr. also had put me one letter, Mr. K. Google and CGC for the rest number 1 and Mr. RP. 225. Petitioner pursued his master degree in development studies at IIT Guwahati from the session 2022-2023. It is submitted by the petitioner that he appeared in his graduation with honors in humanities and social sciences from Delhi University in the year 2022 and passed it the second division. In that extent, the petitioner has annexed a provisional certificate issued by the University of Delhi on 20/02/2023. However, the respondent IIT by its communication dated 02/01/2022 cancelled the studentship of the petitioner from the IIT Guwahati with immediate effect due to non-submission of his qualifying bachelor's degree and mark sheet within the stipulated time. Hence this petition. 021 location 02/01/2023. Respondent and Mother Pishot Annexer Q. But hence this petition. Returnable by 6 weeks as such and such, no formal notice. As so, copy by Monday. Petitioner shall take steps for service of notice on the respondent numbers 6, 7, 8, and 9.
6, 7,
by raised and post daily, providing their correct such and such on or before 14th of March 2023.
In the meantime, I may be allowed to continue my classes. Because otherwise, because
will be considered on the returnable date. Second April. Second April. Sorry, 4th April. Interim priority petitioner in the consideration.
May I please your lordship? My lord, matter relates to provincialization, my lord. My lord, what has happened? I have, my lord, received an instruction from the petitioner, my lord, that he preferred an appeal under 14, my lord, and some order he has said has been passed, but he has not get access of the same. So, my lord, may I pray that this matter may be taken up on Wednesday next, my lord?
Okay, on the priority council for the petitioner, list on 23rd, 22nd.
Mal.
Okay, on 22nd.
Oblige.
Wait, please, your lordship. Not quite a few matters are before lordships today, my lord. Now, pursuant to an advertisement, these petitioners were appointed, my lord, as my lord, assistant professor, technical in Dhemaji Engineering College. Now, my lord, the advertisement lordships will find at page 32. On behalf of the Higher Education Department, Government of Assam, online applications are invited from permanent resident of Assam for appointment to the following post of Dhemaji Engineering College to be made functional from August under so-and-so. The post will be filled up under Regulation 3F of the Public Service Limitation as indicated below, along with the usual so-and-so, so-and-so. Appointment will be purely so-and-so, so-and-so. My lord, pursuant to this, recruitment process, my lord, the petitioner, about 18 number, they were all appointed, my lord. The appointment orders, lordships will find at page 49. Hmm. 17th of February 21, subject to receipt of final police verification report and discharge without assigning any reason thereof, the following persons are appointed temporarily as assistant professor at so-and-so under Regulation 3F in the scale of pay of so-and-so for a period of 4 months. Now, this is how they were appointed, my lord. And these appointments were followed by, my lord, extension orders, which are lordship will find at page 51 to 58. 57. 51 to 57, my lord.
My lord, thereafter, my lord, most interestingly at is 59, if your lordship would come, on 15/12/21. Page 59. In the interest of public service and in pursuance of this department's notification dated 17/2/21 and the cabinet decision held on 24/11/2021, the governor is pleased to approve the ex post facto appointment of the following assistant professors of Dhemaji Engineering College, appointed under Regulation 3F, with effect from the date of joining on usual pay and allowances. Now, ex post facto approval, my lord, most pertinently was with effect from the date of joining without any outer limit. Oh, my lord, we are working now. Now, all of a sudden, my lord, this impugned advertisement has been issued, which your lordships will get at page 61. Now, 61 post has been advertised. Assam Engineering Service Recruitment Board invites online application in the website from permanent resident of Assam having requisite qualification for recruitment to the vacant post of assistant professor in state engineering colleges under higher education. So, my lord, the nomenclature of the post is assistant professor, government engineering college. So, 61 number of post has been advertised. My lord, our case is, since we have undergone a selection process, and that was an alternative mode of recruitment which was resorted to by the state, why should we be again subject to a further selection, my lord? Lordship knows, my lord, if the posts are sanctioned and permanent and vacant post, then, my lord, Regulation 3F will not apply. And in fact, my lord, in one of the judgment, the Honorable Apex Court has said, my lord, this is an alternative mode of recruitment. It cannot be construed as an illegal appointment or a backdoor entry. That is our case, my lord. Now, by subjecting us to further recruitment, my lord, our right to be considered for appointment, our right to continue in our post has been taken away. Now, if your lordship would kindly recollect, my lord, in item number 50 of today's list, my lord, if your lordship would have that for a moment. 1, 2, 6, 4, 3, 1, 1, 2, 6, 7, 2. Sorry, it's 51 to the 51, item 51. Now, my lord, what had happened in this case, if your lordship would kindly take item number 51 for a moment, my lord. In the same manner, my lord, if your lordship would kindly come at page 73. Now, lordship knows for the polytechnic, the post is known as lecturer. For the government engineering colleges, it is called assistant professor. My lord, after a same recruitment, this advertisement was issued on 4/6/22 at page 73, my lord. Now, we put to challenge on the similar ground, and your lordships, my lord, by order dated, if your lordships will kindly come to page 82, the order starts at page 75. In the interim, it is made clear that if the impugned advertisement notice dated 4/6/22 includes the post of lecturer technical in different branches of Government Polytechnic of Assam, also includes the post of the lecturer in the newly established polytechnic in 5 districts, namely so and so and so. Then altogether 27 number of posts of lecturer from polytechnic of those 5 districts shall be kept out of the purview of those 80 number of posts of lecturer in the government polytechnic as advertised on 4/6/22.
I think that is there is some.
No, my lord,
cabinet
what
decision.
happened? Thereafter, my lord, government withdrew the advertisement. Therefore, we had to, my lord, our writ petition became infructuous. Subsequently, my lord, even in item number 51 also, now an advertisement has been issued on 21 to 23, which we have put to challenge. Now, my humble submission is, my lord, once we have undergone a recruitment process, once we have been selected, once the cabinet has given an ex post facto of approval, is there any further scope of subjecting us to further recruitment process, my lord? That is the issue. My lord, I am relying on one judgment of the Supreme Court, my lord. That is 2015-17 SCC 789.
Now we'll have it. 2015.
My lord, 2015-17 SCC 789. My lord, this judgment speaks of an alternative mode of recruitment, my lord, which is legitimate. The appointments in the case were saved even after my lord Umanit. If your lordship should kindly come to page 801, my lord, of the judgment.
Which para?
Yes, I'm reading, my lord, that it's part of paragraph 17, my lord. 17, it starts at 800, but I'll have your lordship's kind attention to page 801. The sub-para starting with reliance on para 33. Has your lordship's got it? Yes. Reliance on para 33, 36, and 47, however, does not advance the case of the appellant, since state government in the present case has carried out recruitment in a regular manner, albeit beyond OPSC, which had presented a panel containing negligible number of SC/ST candidates. This subject challenge recruitment was neither capricious nor arbitrary, but on the contrary was carried out in consonance with known method of selection, that is Rule 4. This was not a case of ad hoc employee being selected in whimsical, inconsistent, or haphazard manner, or in order to favor some individuals. The incumbents were sponsored by the Employment Exchange, and over 400 candidates were found suitable by duly constituted selection committee which interviewed them. It is not a relaxation of the rule in order to favor a few, but was the consequence of following an alternative method of selection intended to remedy a malady in the recruitment of SC/ST. It is well within the power of the state to organize an alternative recruitment drive when insufficient SC/ST candidates are available, and under Article 324 of the Constitution, OPSC was not required to be consulted. In fact, my lord, Article 324 gives the authority to the state in certain cases not to refer to the APS, Public Service Commission, which is the normal mode of recruitment. Now, my lord, there is no dispute in these cases that we were subjected to a selection process. There was an advertisement, we were selected, and we are being paid, my lord, regular scale. If your lordship would kindly come to our appointment order, my lord, at page 49. Scale is 49. Kindly come to page 49, my lord. Subject to receipt of final police verification report and discharge without assigning any reason thereof, the following persons are hereby appointed temporarily as assistant professor at Hema Engineering College under Regulation 3F of the regulation in the scale of pay of rupees 57,000 to 1,82,000 plus other allowances as admissible temporarily for a period of time. So, when the scale pay is given, it has to be sanctioned and a permanent post. So, my lord, two prerequisite for describing an appointment as, my lord, substantive is when the appointment is made to a post which is sanctioned and permanent. My lord, the method of recruitment, there can always be a scope of argument. Even if it is not by the APS, Public Service Commission, my lord, the Supreme Court has considered to be an alternative method of recruitment. So my lord, of course, initially the last date was 13th, my lord, for applying. Now, when corrigendum issued by the selecting authority, now it has been extended to 20th of March, 20. Today we could,
Yes, Mr. Saikia.
so that is my case, my lord.
So basically, any such government post has to be filled up by the APSC,
Hmm.
right? Public Service Commission, the advertisement. Now, as you know that this is, if it is for a temporary period of 4 months or something, the sanction postal media, it can be, the government can fill up those posts. And accordingly, these persons were appointed under Regulation 3F of the 1951 rules. Now, the press advertisement have been issued for those posts which now been sanctioned. Tell us.
The case is very simple, Lordship. Lordship is pleased to look at the first advertisement to which they entered into the service. Page 32.
Yes, yes. We have seen it is under 3F.
3F.
Clear, very.
Advertisement was for 3F. Now let us place what is 3F. The law in this field is very well set.
That's your asking.
There are a series of judgments from the judgments from the 19th century. Here of the Assam Public Service Limitation of Functions 1961. CF says when an appointment is to be made by direct recruitment to a temporary post created in a service, it is necessary in public interest that the appointment should be made immediately and reference to the commission for 2020. Provided that if the post has been sanctioned for or is likely to last for more than 4 months, the commission shall, as soon as possible, be consulted in all matters mentioned in subclause 3 of Article 320 of the Constitution. So their entry or their advertisement was issued under this provision that it is for a period of 4 months or subject to further extension. It can be extension for 2 more periods. So they were appointed under 3F. That is not that they were not appointed in a regular mode. The regular mode is something different. So when there is an urgency in the department and holding a full-fledged recruitment process, it may consume time. Therefore, as a stopgap arrangement, this 3F is resorted to. So they were initially allowed to work and appointed for 4 months, and which was subsequently extended from time to time for a period of 4 months onwards. Now, their whole basis is page 59. Annexure 6. Lordship will kindly note the language here. In the interest of public service and in pursuance of this department notification dated 17/2021 and cabinet sent on 24/11/2021, the governor is pleased to approve the ex post facto appointment of the following assistant professors of Humaji Engineering College appointed under 3F of the Assam Public Service Commission Regulation 1961 with effect from the joining and on usual pay and allowance. So what is approved? Their appointment under 3F has been approved. It is not a case of regularization. Had the cabinet or this notification regularized their service, the things would have been different, which is not permissible. That is a different story. But here, this notification of 15/12/2021 simply says there was no approval for their appointment under 3F of the regulation. So that has been approved. That means their 3F appointment was regularized, not their service is regularized. So my humble submission is that as they were appointed under 3F regulation, it has to be considered under the provisions of the rule. That is 3F. It is not a regular appointment. For regular appointment, we have different set of service rules that I will place. Now, what they are challenging, when there is an urgency and there is a stopgap arrangement, some persons are required in an institution or in a department or 3F has to be resorted to. And that is precisely what has been done here. Now, when this advertisement, in advertisement of 21/2/2023, this is a regular appointment. There is a huge difference between the advertisement which they have, that at page 32, advertisement number 1 of 2022. Specifically, it is said that it is their appointment will be purely on ad hoc basis. Lordship will kindly see page 32, the first paragraph, last 2 lines. The appointment will be purely on ad hoc basis for a period of 4 months, as per regulation 3F of the APSC. So when they entered and participated in the recruitment process of this advertisement, Lordship, with their eyes wide open, they participated in the recruitment process. That it's a 3F appointment.
They're fully aware.
They were fully aware. They knew that this is a temporary arrangement. The recruitment is for temporary purpose. While doing so, lot of other candidates, they never participated also. Now, if we regularize that, it will be doing injustice and it will be prejudice to the candidates who have not participated for this 4 months exercise.
No, that's the judgment of the apex court.
Yes, Lord.
That's the judgment of
That's
the
a judgment. That's a settled position of law. When I apply for this 3F appointment, suppose I am studying. I will not leave my study and come for a job for 4 months. So I did not apply for this. So now, on the basis of this recruitment process, where they know that their appointment is for 4 months, which can be extended till a regular appointment is made. So, on the basis of this, and on the basis of page 59, they do not have any right to challenge this advertisement. Page 59 very clearly says that cabinet as well as this, there are this department notification of 17th and cabinet decision of 24/11. That has given approval ex post facto for the appointment of the assistant professors of Seniority Engineering College appointed under regulation 3F. Nowhere we can read this particular notification as an order of their regularization in service. That is not permissible at all. Summative judgment and series of other judgments. Moreover, the law which is very clearly laid down is the regulation of 1951 as well as the service law, service rules which I am going to place now. So now the present advertisement also will see page which is under challenge, page 61. Assam Engineering Service Recruitment Board (AESRB) invites online application in website so and so from the permanent residents of Assam having requisite qualification for recruitment to the vacant post of assistant professors in the state engineering colleges under Higher Education Technical Department, Government of Assam, as indicated below. So this is the advertisement under the rules. We are not resorting to 3F here. 3F is a totally temporary arrangement. Now it is the permanent arrangement. This takes time. This is an elaborate recruitment process where we have to strictly abide by all the recruitment conditions as laid down in the service rules. Service rules may have place it not. They are governed by Assam Technical Education Service Rules 1981. The Assam Rule of 1982. Here, there is a mode of appointment of direct recruitment. Rule 5. Have lots of problems.
81, right?
1981. Rule 5. Mode of method of recruitment. Recruitment to the service shall be made in the manner prescribed hereinafter in the cadre of so and so, in the cadre of principal, then in the cadre of lecturer, polytechnic, by promotion in accordance to so and so, by direct recruitment in accordance with Rule 6(1) and 18. The percentage of the strength of each of the cadres to be filled by promotion or by direct recruitment shall be as below. Lecturer, polytechnic, 33 1/3% of total strength, 62 2/3 of the total cadre by the share, direct recruitment and promotion. So 33% direct recruitment. There is no scope of 3F appointees here. Had there been the intention of the legislature to include any persons who are appointed under 3F to be a regular member of service, there would have been another category there. That category is not there. So direct recruitment covers under rules 6. Subject to subrule 2 of rule 11, direct recruitment to the cadres as mentioned in subrule 4 and 5 of rule 5 shall be made by the governor on the basis of recommendation made by the commission in accordance with the procedure herein after provided. The whole procedure is laid down in rule 6. Rule 7, age for direct recruitment, director, principal, assistant professor, engineering college, workshop, etc. Various posts in Roman 3. Academic qualification is given. And rule 11 onwards, Lordship, this is for the purpose of promotion as lecturer of the polytechnics. So that is not required for our purpose. So whoever is a member of service in the capacity of assistant professors in various engineering colleges, polytechnics, etc., Lordship, they are governed by the engineering service rules of 1981. And there is no scope of regularization of the candidates who were appointed under 3F here. In fact, they do not have any right for regularization. What they are trying to impress upon this honorable court is that approval of the 3F appointment, they are trying to give an impression that that was an order of regularization, which in my humble submission, plain simple language is there. There is no ambiguity in the same notification, which they are strongly harping upon at page 59. That is purely for the purpose of taking the ex post facto approval of the cabinet as well as the notification regarding their 3F appointment. There has been no exercise in the government or in the department to regularize their services. The earlier round, Lordship, there was a litigation on the same point when we have cancelled the whole recruitment process because the OM, on the basis of which the recruitment process was to be carried out, that was of 30th May 2022 or 2021. We have recalled that notification. For that purpose, the earlier recruitment process was abandoned. This is a fresh recruitment process under the new guidelines. The Supreme Court judgment will not help them, which my learned senior friend was relying upon, because there is a huge difference of the factual aspect. We are totally governed by a service rule in place. And the law which is laid down in various cases of the division of this honorable court.
Exactly. Our division bench have
Time
earlier
and
passed,
again.
there is a specific judgment.
And the very recent judgment notified case by a single judge, but the division bench judgment notified any judgment 1996 GLP page 310 division bench comprising of my lord Justice Khanna and my lord Justice Patnaik, Deborbrata Borgohain and others. There is batches of cases. Judgment was delivered on 18 September to 1996. Paragraph 16. The law thus has been enunciated by apex court. Let us examine the case of the officers who have been appointed under Regulation 3F and whether any of their rights under the statutory provisions, the appointment letter or the constitution has been violated. The statutory provision of Regulation 3F makes it clear that appointment under is a purely temporary pending reference to and selection by the APSC. The appointment letters issued to 3F appointees clearly contain a clause that the appointment being under Regulation 3F continuance in service vis-a-vis regularization in service thereof will depend upon his being selected by APSC with the required position in the list of candidates recommended by APSC for regularization. It will be the responsibility of the appointee to apply and to appear in the selection notified/advertised by the APSC for filling up the post of junior engineer, and in case he does not appear or is not able to appear, or in case he is not selected by the APSC within the required position of the select list, the appointment will stand automatically terminated. From the facts narrated earlier, it is clear that except the two petitioners in so and so, all other appointees under regulation 3 have the opportunity of appearing in APSC selections for public employment. Hence, their right either under Article 14 and 16 of the Constitution or Regulation 3F or their appointment letters have not been violated. All these appointees except two did apply and appear in thus did avail of a chance at the behest of such appointees under Regulation 3F who have been found unsuccessful. This court, in exercise of its extraordinary jurisdiction under Article 226 of the Constitution, will not grant them any relief of watching the selection of candidates by the APSC in excess of the advertised post or in continuing them in the post to which they are temporarily appointed pending regular selection by the APSC. So what they are trying to do is now, Lordship, that they are challenging. What is their prayer? Till now, they are not regularized. They are holding the post on the basis of their appointment order. Lordship, if Lordship is pleased to take up another petition 1271, where there is an appointment order.
1 my size.
No, we are in 1271.
Yes.
Yes, Lordship. Page 49. 17th February 2021. Subject to receipt of final police verification and discharge without assigning any reasons thereof, the following persons are appointed temporarily as assistant professor at Hemaji Engineering College, Hemaji, under Regulation 3F of the APSC, Regulations 1951, in the scale of pay of 57,000 to 182 plus other allowances as admissible temporarily. Lordship will kindly mark this, temporarily for a period of 4 months only with effect from the date of joining. Very clearly it has been mentioned in the appointment order. These appointments are purely temporary and liable to be terminated at any time without notice and without assigning any reasons thereof. Their services are transferable and liable to serve the exam. So we are not terminating them, Lordship. Now we are going to hold the regular selection and they have to give way to their position, to their post. If they participate in the recruitment process and they are selected to a regular recruitment process, they will definitely retain their post. Even that also their seniority will not come. Because that is another story. There are other settled position of law. The appointees should report for duty with respect within 15 days from the date of issuance of this notification. So this was issued on 17th February 2021. Thereafter, after the expiry of 4 months notice, they were getting extension orders. So their whole basis or their whole enforceable rights emanates from this particular appointment order, where it is very clearly said that their service is for 4 months. It is a different story that the recruitment process could not be conducted after the expiry or within the period of 4 months. But that will not give them any other right which they can enforce under 226. Now that process has started, which they want to stop. Nobody is stopping them from participating here. Now there are total posts. Then another judgment, another division bench judgment, 2000 volume 1 GLT page 429.
Case number 2.
2000 volume 1 GLT page 429. My Lord Justice Vijay Kumar, the then Chief Justice, and My Lord Justice Biswas judgment. Paragraph 11 and 12.
The 1996 judgment, any specific, any paragraph 16 you are talking about?
Paragraph 16. And I will place a very recent one, Lordship. After this. paragraph 11. The regulation 3F of the regulation of 1951 came up for consideration by the division bench of this court in Hemanta Kumar Pegu versus State of Assam, 1988 1 GU, 383, 1989 1 GLR, etc. The division bench considered regulation 3F and held in paragraph 27 of the judgment that this regulation does not provide a source of power for appointment, but only provides the mode of appointment that regularized cannot permanence. The contention that the person who have appointed under regulation 3F can be regularized if they are otherwise qualified was not accepted by this court, and it was held that regularization means making regular appointment by selection irrespective of the question whether the petitioners were already appointed under regulation 3F or not. The ratio laid down in the above decisions, in our opinion, is the correct proposition of law, and there is no reasons to take a different view. Therefore, in view of the above ratio, we are constrained to hold that merely because the appointments of the appellants were converted to appointments under regulation 3F of the regulation of 1951, they cannot claim regulation due to length of their service in the instant case. Although there is no recruitment rules prescribed, the appointments are required to be made on the recommendation of Public Service Commission. Pausing here for a moment. In our case, there is a regulation in place. And now, another new regulation project we have amended. Instead of APSC, there is a recruitment board for engineering services. The commission normally, on request from the government, advertise the post and select candidates after interview. The state is required to make appointment from the merit list prepared by the commission, and the seniority of the incumbents are fixed in order of preference/merit indicated in the select list. That being the position, it would be difficult for us to accept the argument that an appointee under regulation 3F is entitled to seniority with effect from the date of his initial
That's again a different
That
issue.
is what I have just submitted.
That is not our case.
From the
Not-
discussion
we are
above, it follows that the government have no power to make appointment under regulation 3F to any substantive or permanent post.
Yeah, this is the point.
And when appointments are made on ad hoc or stopgap basis, divorce the rules, the appointees under regulation 3F will not be entitled to seniority with the effect from the initial appointment. However, the appointees under regulation 3F shall be entitled to seniority with effect. That is not the issue. So now we cannot make them permanent, the ad hoc appointees. One single, another division that's 1995 1 GLR 229. Honorable Justice Khanna and SN Puttam. 1995 1 GLR 229, paragraph 11. This regulation 3F of the regulation of 1951 came up for consideration by the division bench in Hemanta Kumar Pegu. The division bench considered regulation 3F and held in paragraph 27 of the judgment that this regulation does not provide a source of power for appointment, but only provides the mode of appointment, and the regularization does not connote permanence. The contention that the persons who were appointed under regulation 3F can be regularized if they are otherwise qualified was not accepted by the court, and it was held that the regulation means making regular appointment by selection, irrespective of the question whether the petitioners were already appointed under regulation 3F or not. The ratio laid down in the above is the correct proposition of, and there is no reason to have a difference. Therefore, in view of the above ratio, we are constrained to hold that merely because the appointments of the appellants were converted to appointments under regulation 3F of the regulation of 1951, they cannot claim regulation due to length of their service. And another judgment for 2007 1 GLR page 260, Kamal Kumar Mohanta versus State of Assam. This is a single judge's judgment. Paragraph 8. From observations made in Santanu Borua, Supra, and Devarpatra Bormohai, it becomes abundantly clear that appointments made under regulation 3F are purely temporary in nature until regular selection is made by the commission. Once regular selection is made, the appointee under regulation 3F must make way for the regular selectee and the government must appoint the regular selectee by terminating, if necessary, the service of the appointee under regulation 3F. If an appointee under regulation 3F desires to be permanently appointed, he must apply and appear in the selection process when the post which such an appointee is holding is advertised by the commission for filling up the same by regular selection process. If the appointee under regulation 3F does not appear or does not get selected in the regular selection process, the appointment of such an appointee shall, on regular selection being made, stands automatically terminated. In the case in hand 2, when the selection process commenced, all the private respondents who are appointees under regulation 3F did participate in the same selection process but failed to make their way within the 8 candidates finally selected in the merit order of merit. So they can also participate, and if they are selected, they will get their post. Otherwise, they do not have an indefeasible right to hold on their post, in which they entered through 3F. And the recent judgment, Lordship, very bulky judgment. All these judgments were considered. It's a very elaborate hearing where I was also part of the adjudication. This is WPC 617/2020. Judgment was delivered. I'm not sure whether it is reported or not. It is not visible. 43/2022. It is. This is reported in a different journal, where all the senior counsels appeared, most of them, Lordship, and all these judgments were discussed. Paragraph 36 onwards. If I am allowed to read, Lordship. Paragraph 36. Regulation 3F of the APSC Regulation 1951 has inter alia provided that when an appointment is to be made by direct recruitment to a temporary post created in civil service and post, if it is necessary in the public interest that the appointment should be made immediately, and the reference to the commission would cause undue delay, the commission is not required to be consulted in matters relating to the method of recruitment or with regard to the suitability of the candidate for such appointment. The proviso 2, it has provided that if the post has been sanctioned or is likely to last for more than 4 months, the commission shall as soon as possible be consulted inter alia in all matters mentioned in subclause 3 of Article 320 of the Constitution. Regulation 3F of the APSC Regulations 1951 has indicated that an appointment made under Regulation 3F shall be in a post which is temporary in nature. If the state government is of the view that there is an immediate need to make an appointment in such temporary post and the reference to the commission would cause undue delay, the state government can make such appointment in the temporary post in a service or post by way of direct recruitment under Regulation 3F. From the narrative of Regulation 3F, it is clear that an appointment made under Regulation 3F is purely ad hoc in nature until the regular selection is made by the commission in accordance with the provisions laid down in the concerned service rules, if any, and in the absence of service rules, in the manner consistent with Article 14 and 16 of the Constitution of India. The proviso has further made it clear that if the post has been sanctioned or likely to last for more than 4 months, the only option available is to fill up the post in a regular selection process held in consultation with the commission. As a natural corollary, once regular selection is made, the appointee who is working in the post by virtue of his appointment under Regulation 3F has to make way for the candidate selected through the regular selection process, and the government appointing authority, when candidate selected through the regular selection process is available, has to give appointment to such regular selectee, and it shall not be open for the government appointing authority to keep such regular selectee at bay while allowing the appointee under Regulation 3F to continue working in the post. If such an eventuality arises, the regularly selected candidate has to be appointed even by terminating the services of the appointee appointed under regulation 3F of the APSC regulations 1951. So very categorical, Lordship. Paragraph 40 of the said judgment. Having accepted the position that in the event they are selected and recruited in the advertised post pursuant to the advertisement of 14/8/2018, they were appointed only under regulation 3F of the regulations.
And that's what the law laid down by the Apex Court. That's
And
once.
they would not be treated as regular appointees. All the appointees are precluded from making the prayer for regularization. The principle that one cannot approbate and reprobate is found applicability in the cases of the petitioner. The principle that an ad hoc appointee appointed under regulation 3F of the APSC cannot claim regularization and has to make way to the regularly selected candidate as authoritatively laid down in the decisions mentioned above applies proprio vigor in the cases both the sets of petitioners and so on. The law is well settled in this aspect. Now, what is their prayer? Lordship will kindly see. It is an undisputed position that they are working under regulation 3F, initially for 4 months, which are subsequently extended. So now their prayer is to issue a writ in the nature of certiorari or any other appropriate order or direction or like nature for setting aside the quashing the impugn advertisement 21 to 2023 issued by the Assam Engineering Service Recruitment Board to the extent of advertising the vacancy of 8 numbers of present petitioners are holding, 8 number of posts the present petitioners are holding as assistant professor at Dhemaji Engineering College. So this is first prayer. What is the justification on this prayer, Lordship? They entered service for 4 months, which was subsequently extended. The law is well settled by a series of judgments for last 30 years that they do not have any right to continue and they cannot seek regularization. The judgments also says that they will continue to hold the post under 3F till a regular selection process, and it is the bounden duty of the government to hold regular selection process. So this impugn advertisement is an act of in that direction to have regular selection to the permanent post. Now what they are saying that 8 posts should be kept aside from the recruitment process. Next page. A writ in the nature of mandamus should not be issued directing the respondent not to fill up the post wherein the present petitioners are being appointed by order dated 17 to 2021. I have already placed 17 to 2021 where it is very clearly said it is a temporary post ad hoc appointment for a period of 4 months. What special right they have that this honorable court will exercise power under 226 to give direction that they should continue. In spite of their original appointment order says only 4 months. They are already lucky to continue on the basis of that 4 months order for another 2 years. They should rather give thanks to the government. Not to fill up the post wherein the present petitioners are being appointed by order dated 17 to 2021 issued by the Higher Education Technical Department for the post of assistant professor at Dhemaji Engineering College, and subsequently the said appointment being approved by from the date of joining by notification of 15/12. So their whole basis is that 15/12/2021. That says approval has been given by the governor for their appointment under 3F. It is not a regularization order. Even if a regulation order was given, that would have been a violation of all the settled position of law, including the statutory law. Prayer 3. To issue a writ in the nature of mandamus or any other appropriate order or direction to the respondent authorities, not to bring the post held by the petitioner under the purview of the advertisement of 21 to 2023. This prayer is an illegal prayer, in my humble submission. D. To issue a writ in the nature of mandamus or any other appropriate or direction to maintain status quo in regard to filling up of the 8 posts held by the petitioners. So when the government wants to regularize the whole system, they want to act as a spanner. This is another illegal prayer. Then E I am skipping, that is a innocuous prayer. Now, what is the interim prayer? Pending disposal of the writ petition, your lordship may be kindly to please to stay the recruitment process for the post wherein the present petitioners are serving as assistant professor at Hemadi Engineering College, initiated through the advertisement dated 21/2/2023 by the Assam Engineering Service Recruitment Board for the recruitment to the post of assistant teachers till the disposal of the writ petition, and not to fill up 8 number of posts wherein the writ petitioner are presently serving, or direct the respondents to maintain status quo with regard to the services of the petitioners, and to be pleased to pass any further orders. So my humble submission is that what is the legal right they have? Are they able to make out a prima facie case in their favor? They do not. The facts are very clear. The facts are very clear. The main facts which is to be considered is that what is their right of appointment? Their right of appointment emanates from Regulation 3. Regulation 3 says appoint them temporarily for a period of 4 months. That 4 months period has long elapsed. We are more than 2 years now from their appointment. So PF does not give them any enforceable right for them to seek any remedy for this honor report under Article 226. Now, where is the illegality? Lordship will have to find some illegality if Lordship wants to interfere with the recruitment process in terms of the advertisement of the first of April. Where is the illegality? Where is the violation? Where is the ability? We have not violated any law. It is the duty of the government. Once a 3-year appointment is made, the next course for the government is to go forward and have conduct a regular recruitment process. That recruitment process is governed by the rule of 1981. Is there any violation thereof? When we found that there was some sort of infirmity by issuance of that OM of 38 May last year. So we recall that advertisement. Now everything is set here, and they are not challenging any of the recruitment guidelines or the recruitment process or the selection process. Their only thing is that they want to continue on the basis of their 4 months appointment order. This is their whole case. In that view of the matter, in my humble submission, if Lordship wants, we can file an affidavit, but no affidavit is required. From the facts which they have narrated in the writ petition, it is sufficient. The law is well settled. So our argument, Lordship may finally dispose of the petition also today. I do not have any further arguments to make. I have placed all the judgments, holding the field, the facts which are not disputed. Had there been any disputed fact, Lordship, I would have filed an affidavit. But for that purpose, Lordship, no affidavit is required in the instant case. So in that view of the matter, in my humble submission,
Just tell us one thing, Mr. Saikia. The last extension was given on up with effect from 22nd of October.
That means
2022.
Yes.
For a period of 4 months.
That is also over then.
Now, whether after that period of 4 months has it been extended?
Suppose no extension, they have no right. Suppose an extension is given, then also they have no right.
No, both way. Just still
Both way.
extension. has been
Suppose an
granted.
extension is given today, they have a right for another 4 months. But our recruitment process will not be over and will not violate that extension order. This is my another concession or my commitment before this honor report. That we are not going to violate any extension order.
Okay.
If they have a period of extension, that will not be touched. The place recruiting will be appointed only after expiry of their extension order, if at all it exists. It is their duty to place the complete record. So, in my humble submission, with the ongoing process, it is badly needed, and the deserving candidates are waiting for regular appointment.
My lord, today, my lord, it will be difficult, 2 o'clock and another partner matter is going on. Monday or Tuesday, my lord, will give my reply, my lord. My lord, we are not disputing the power, the legal position with regard to 3F. My learned friend has not read the petition. That is why he has made up arguments which are not even necessary. All that we are saying is, since these are permanent posts, you cannot invoke 3F. That is our case. Our case is not about what is 3F. All the time, my learned friend was arguing is what is 3F. We all know what is 3F. For that, the judgment is not required. On the contrary, there is a judgment of this honorable court where, my lord, this honorable court has said you cannot invoke 3F in such a situation. That is our case. And I'll explain my position either on Monday or Tuesday, my lord. I'll give her half an hour time, 15 minutes time, my lord.
My one-liner is that if 3F is not applicable, then they are not in the survey.
Anyway, my lord, let us not do this delaying. We are on a different, my lord, service jurisprudence is not a static thing. What was decided 30 years back may not be relevant today. Law is changing. It must adapt to the social changes. Therefore, my lord, let us not bring in judgment every time. When legal positions are very clear, we need not rely on judgments, my lord. Judgments are required when legal position is, slippery, or maybe taken a different view. When positions are clear, we don't require.
By sleep Monday.
My lord?
By sleep Monday.
Monday. Yes.
Highly of.
31, my lord. Then, my lord, subsequently, again, my lord, my name was appeared, but ultimately, my lord, by in order, that, my lord, they have brought one politician and one vice president, my lord, whose name has never been recommended, my lord. Lordship will see, firstly, my lord, our name appeared.
Mr. Borgia, this is an order of 16th of December. We are in March.
March, my lord. Thereafter, my lord, our name newly, my lord, it has been recommended, my lord, page 33, my lord.
No, that's the order is in force, right? They are the persons who have been selected for the post of president and vice president.
And impin order, my lord, is a very recent order, my lord, that your lordship will see at page 87, last page, my lord, 16/12/22.
And that's what we are saying. They might have taken charge by this time.
Well, even though, my lord, they cannot, my lord.
They were here counsel appearing for the petition.
And he is a political person, my lord. I have got the copy also.
And Mr. Assembly System Standing Council, Department of School Secondary Education for 1, 2, and 5. 1, 2, and 5. Also had MSD as Government Advocate Assam for the respondent numbers 3 and 4. Matter pertains to the post of
Page 87, my lord. President and Vice President SMDC of Narayanpara High School.
Okay. Matter pertains to recommendation and approval of the respondent numbers 7 and 8. As the President and Vice President of the School Management and Development Committee of Noyapara High School, Noyapara, Matia District, Kolpara, a provincial secondary school of the state. Petitioner contended that the respondent number 7 has been considered to be the president of the high school, as involved in politics. Respondent number 8.
Name never said.
The vice president of the state, vice president of the assembly of the state high school, whose name was never recommended at all by the headmaster as well as the local public of the school where it is situated. And as such, the recommendation of the respondent number 7 and 8 as the president and vice president of the assembly of the such and such high school is in violation of the notification of the state government and secondary education sum dated 27/06/2016. There is another notification, right? There are two notifications. 27/6 notification. State petition. It's a notice returnable by 8 weeks. As such and such no formal notice. Steps by Monday. Petitioner shall take steps for establish of notice under response number 678 by raised depository on or before 14th of March. Right. The considering the approval of the response number 7 and 8 as the precedent of the assembly of the such and such high school, the way of 16/12/2022. Status quo is on today with regard to the assembly of state.
Status quo, my lord, they are holding, my lord. It
However,
has to
it
be
is made
stayed.
clear
now.
that their position as a president and vice president of the assembly of the city high school shall be subject to the outcome of this petition.
If it is state, my lord, then otherwise.
16/12. Still reflecting more school education, whether it's government advocate has been shown. Study council secondary education. Mr. Deka, is it?
May it be, Lordship. Lordship, here, Lordship, the grievance of the petitioner is that, Lordship, an unqualified teacher, Lordship, who is also junior, then the petitioner, he is allowed to hold the charge of the high school, Lordship, since 2018. So after completion of my BA degree, Lordship, I have filed a representation that was forwarded to the authority, Lordship. Lordship, may kindly come to page 10, annex 29, Lordship. Here, Lordship, the inspector of schools, after forwarding the seniority list, he forwarded to the director, but till date, Lordship, the authority has not taken any action, Lordship. Lordship, kindly see the annex 10, page 29. No instruction is required, that be annex 11. It clearly reflects, Lordship, kindly see the serial number 1. His date of receipt, Lordship, page 30, annex 11, the seniority list. The serial number 1 is the response number 5. Lordship, kindly come to the column number 11, date of receiving graduate scale, 1995. So for the petitioner is concerned, the serial number 4, he is the petitioner. The date of receiving graduate scale is 6/11/1993. So apparently, let's say I am senior and having BEd qualification also. But in spite of Lordship filing this representation, the authority has not taken any decision till date, Lordship. And Lordship is very much aware that they are in view of Jagannath Pegu and number of Lordship division bench order, Lordship. For even for insertion, Lordship, if somebody is not having qualification, they cannot continue, Lordship. Because I am relying on that 2007 and 2015 GLR, Lordship, division bench order. So my Lordship, prayer is that Lordship may give a direction to the authority to consider my grievance of the petitioner, Lordship. Till then, Lordship, the inspector of schools may be allowed to hold the charge. Within a time term, Lordship, let the authority take a decision, Lordship.
Administrator Edeka, council appearing for the petition.
And for 1, 2, 3.
Assembly state standing council for the response number 1
to
4. Petitioner was appointed as a science graduate teacher in
Kakori MV School Lodge.
Kasuri MB School.
Let's see the annexure 11 page 30 reflects everything. Lodge. Date of appointment, date of amalgamation, date of joining. Annexure 11 page 30. Column number 7, 8, 9.
District of Nagaon. By order dated 06/11/1993 issued by the BO Nagaon. Person to which joined the said post. On 6/11/1993 itself. Since then, he is receiving graduate scale of pay. Said Kasuri MD School was amalgamated with Kasuri High School, another provincial secondary school of the state. By an order dated 20/06/2017. Issued by the Director of Secondary Education Assam on being approved. Where is that amalgamation order?
I'm sorry, I am not connected, so it's not correct.
Was amalgamated
But date of eligibility
with effect from 6
2017.
20/06/2017. Thereafter, the service of the petitioner brought under the Directorate of Secondary Education Assam, within the jurisdiction of the Inspector of Schools, Nagaon. The petitioner obtained his B.Ed degree year 2021.
By September 2021.
September 2021. And he completed the said course, 2 years course. On being deputed by the Director of Secondary Education Assam by the order dated 09/07/2019. Petitioner stated that respondent number 5, an assistant teacher without the B.Ed degree is presently holding the post of headmaster on in-charge basis of said Kasuri High School, who received his graduate scale of pay with effect from 01/08/1995. Petitioner submit by placing the seniority position of the amalgamated Kasuri High School that contains the name of the teachers of Kasuri MB School after amalgamation of Kasuri High School. It was forwarded by the Inspector of Schools, Nagaon, to the Director of Secondary Education Assam on 1/11/2022. Placed before the court that said respondent number 5 is junior to the petitioner, as he received
As they said, respondent received graduate scale of 3 years later than the petition. Later than the relief. It is also contended by the petitioner that the response number 5, since doesn't have the BA degree, is not
Is a non-BA Lord.
authorized to hold the post of headmaster in charge of this Kesri High School as doesn't possess the requisite eligibility to be a headmaster of a secondary school, the state of Assam, as provided under the provisions of 2018 Rules Control Directive. In that regard, Mr. Decker, counsel for the petitioner, placed reliance with the judgment of this court in the case of Jagannath Pegu versus State of Assam, and others reported in 2000.
7.3 GLT, page 389, paragraph Lordship 10. And there's a division bench order Lordship 2016 5 GLR 52, paragraph 1 2 Lordship.
5 GLR?
Yes, 2016 5 GLR 52.
Party name?
Party name is Anwar Firoz Mehdi. Date of decision is 7/6/2016 in the writ appeal number 75 of 2015, as well as writ appeal number 115 of 2016. But I have a copy.
Decided when? Decided when?
Decided on 7th of June 2016. 75 of 2015. Your Lordship, direction is given to the authority to make an alternative arrangement for the eligible candidate, from the eligible candidate. Other also Lordship, since 2018, the school is running without a regular headmaster Lordship. So there is one of my prayer for regular selection also.
Mr. Sisti,
Yes, Your Lordship.
we have the 2018 rules.
Yes. Your Lordship.
Rule 14
Yes, Your Lordship. Recruitment to the post of headmaster.
to be
He must have at least 10 years of teaching experience as graduate teacher, provided that the graduate teacher shall include the cadre assistant headmaster for the purpose of selection to the post of headmaster, and the seniority of the assistant headmaster shall be counted from the date of joining as graduate teacher with graduate scale of pay. Provided further in that case of amalgamated high school, where ME school has been amalgamated, the assistant headmaster is eligible for selection as headmaster, subject to the condition that the incumbent should have at least 15 years of teaching experience as graduate teacher, including the period of service in erstwhile ME school.
now only those persons can be considered for promotion to the
Eligible.
post of
Headmaster.
headmaster. So any such headmaster of amalgamated MEMV school will be the assistant headmaster
Yes, sir.
in the high school, right?
Yes, sir.
So, now, and such assistant headmaster should have minimum of 15 years of teaching experience as graduate teacher,
Yes, sir.
including the period of service, right?
Yes, sir.
Now, yes. Please come to rule 24.
The seniority. The seniority of a member in a cadre appointed by the direct recruitment shall be determined according to the order of preference in the respective select list finally approved under the rule 8.2 in respect of postgraduate teacher or graduate teacher if he joins the appointment within 15 days from the date of receipt of the order of appointment or within extended period as mentioned in rule 19.
Now read rule 5 and 6. Same rule.
Yes.
Same rule. Sub rules.
Sub-rule 5.
And
Yes,
sub-rule
in case of
6.
amalgamation of ME, MV, LP school with other high secondary high schools under the scheme Shiksha Khetra, the employees of amalgamated school shall be given seniority with effect on the date of joining on substantive appointment or regularization. Provided that in case of graduate teachers, the seniority shall be counted from the date of getting salaries meant for a graduate teachers. Provided further that in case of contractual teachers, seniority shall be counted from data absorption in the sanctioned post carrying regular time scale of pay. The seniority of the headmaster of a ME of the MV school subsequently amalgamated with higher secondary high school shall be counted from the date of getting pay in graduate scale of pay.
So here we have seen that only the assistant headmaster serving the high school after such amalgamation will be eligible for
the headmaster. Yes.
So we do not know whether petitioner was a headmaster or what, right?
No, petitioner is also assistant graduate teacher also.
He's a science graduate.
Yes, science graduate teacher.
Science graduate.
So we respect from 1993 also, I am getting graduate scale of pay. So in view of all the provisions of these rules, 14 and 24 also, I am eligible also. Because here it is about the substantive appointment, that is the permanent appointment. So permanent appointment is my 1993. So we reflect from that of permanent appointment also, I am getting.
Behind the provisions of Rule 24. And then bracket 5 of the 2018. Petitioner submitted. Yes, Seniority, respondent number 5. Has all the requisite eligibility to be the headmaster of a provincialized secondary schools in the state of Assam. In the state legal, in the state Kashmir provincialized high school. After hearing the land counsel for the parties and considering the entire city matter, the petitioner is directed to submit a fresh representation before the Director of Secondary Education Assam within a period of 15 days from today. Or no, before 30/03/2023. Along with a certified copy of this order. Studying his grievances. In the event of filing such representation by the petitioner, the Director of Secondary Education Assam, after hearing the petitioner as well as the response number 5 and getting the 11 reports from the Inspector of Schools now, shall dispose of the said representation of the petitioner with a speaking order intimating him about the outcome of the same.
Region order may be passed within a time.
Along with the certificate copy of the repetition, they may serve because it is disposed at a motion stage with annexers.
So time frame is given.
The Director of Secondary Education Assam will dispose of such representation of the petitioner within a period of on or before 31st of May.
So till then, the Inspector of Schools may be allowed to hold it because the division bench order is very clear. Since all the petitioners not eligible, that is why direction is given to the authority to the Inspector of Schools to hold it charge.
Let the director take a decision, Lordship.
We'll take a decision.
Because since 2018, Lordship, kindly appreciate the facts of the case, Lordship. Since 2018, Lordship, for long 5 years, the school is running without a regular headmaster, Lordship. They know the fact, Lordship, well, Lordship.
Okay, we'll clarify.
Lordship. Apply, Lordship. Apply, sir.
Wait, please, Your Lordship. My lord, the petitioner has come with a very limited prayer, my lord. This petition basically is filed because, my lord, he being an eligible candidate to participate in a recruitment process in pursuant to an advertisement, which my lord could find at page 31. My lord, he is an aspiring candidate to this particular advertisement, wherein, my lord, the post of assistant professor has been advertised. And at present, he is serving as a contractual assistant professor in Johad Engineering College, my lord. And to his, my lord, credits, he has, my lord, a patent also recently awarded by the Government of India and has all the experiences required under the relevant service rules, my lord. But the hurdle here is that, my lord, he is not able to fill up his form and participate in the selection process because there is a, my lord, overage of 1 month. My lord, he is overaged by 1 month, then the last date that has been fixed by this advertisement, my lord. If I may take my lords to page 32 of the advertisement, the age has been prescribed, my lord. May I read, my lord? Age. The candidate should not be less than 21 years of age and not more than 38 years of age as on 1st of January 2023. My lord, he belongs to a general category. So we are relying on an office memorandum of 1951, my lord, wherein, my lord, government has been, wherein, my lord, government is given the power to exercise to condone, my lord, overage of suitable and deserving candidates, my lord. Hello. I would like kindly come to the relevant service rules, which also provides that certain relaxations can be given to the candidates, my lord. If I may give a copy of the rules, my lord.
Yes, who is appearing for the other side?
I'm just 1 month overage.
Mr. Das, tell us which provision will be applicable.
I can serve one extra copy.
I have this book.
Yes.
You have the copy of the government circular?
Yes,
1951.
1951, actually, my lord, I made an endeavor to search, but I could find a judgment of this honorable court relating to the similar issue, wherein, my lord, the issue has been decided by this honorable court pertaining to my age relaxation. There, my lord, the OM has been reflected. I'm sorry, my lord, I could not get the original OM, my lord, which your lordship will find at paragraph number 27, my lord.
Judgment, right?
Yes, my lord, 27 paragraph.
Where he has put it, I think so.
Yes, my lord, that judgment quotes the office memorandum of 1951. In this judgment also, my lord, case also, similar issues was before this honorable court, and the court has passed an order in favor of the petitioners to relax the age, my lord, wherein, my lord, actual contention was that 1980 and 1992 subsequent OM, they have assailed, but court has struck down those two and has upheld 1951, my lord. And accordingly,
Mr. Das, whether this 1951 rules will, the notification or the OM will be applicable, or section 28. Not section, rule 28. of the 1951 rules will be applicable.
Rule 28, my lord, governor has power to, my lord, to relax the rules, my lord. Technically, the revision rules, my lord. And for that, my lord, a separate notification has to be issued, my lord. For relaxing the rules, if it is ongoing, my lord.
Mr. H. Muragohai, counsel appearing for the petitioner. For the respondent numbers 1 to 4. The chairman of the Assam Engineering Service Recruitment Board, respondent number 4. On 21/02/2023, issued an advertisement for filling up of 61 vacant posts of assistant professors in government engineering colleges of Assam, including 15 posts of assistant professor in mechanical engineering, out of which 6 are under unreserved category. Petitioner obtained his master's degree in mechanical engineering and pursuing his PhD in mechanical engineering department of Jorhat Engineering College, Jorhat under Dibrugarh University. He is also presently serving as a part-time assistant professor in Jorhat, Assam since 06/09/2021. Though petitioner has the requisite eligibility for the post of assistant professor in government engineering college or assistant professor in mechanical engineering, government engineering college of Assam, but as provided in the said advertisement dated 21/02/2023, the petitioner has crossed overage limit of 38 years.
1 month.
Just by 1 month. As his date of birth as provided
At page 52.
in his admit card for the board class 10 HS high school level certificate examination 2000 issued by the Board of Secondary Education Assam is 01/12/1984. The petitioner has filed an application before the Principal Secretary Government of Assam in the Higher Education and the Technical Department 02/03/2023 to condone his overage, enabling him to apply for the said post of assistant professor in the mechanical department, the government engineering colleges of the state. Same is yet to be disposed of. As nothing progressed, petitioner has filed this petition, waiting for a direction. For 1 month, enabling him to participate in the selection process in terms of the said advertisement issued by notice dated 21/02/2023 noted above. In this regard, petitioner has placed the office memorandum of the state government notification number AAP-34/50/27 dated 03/05/1951. Available in the handbook of general circulars of Government of Assam, which is as follows. That was like a mention. What? A coordinate bench of this court, in the case of Pranav Kumar Dekha and 36 others versus State of Assam and 5 others. WPC number 845 of 2014 and other connected cases. Wait. Judgment in order by the order. There is 0308-2015. Held that said notification dated 0305-1951 was issued by the governor in exercise of the power conferred by the provider to Article 309 of the Constitution. And as such, it has a statutory force. And it would continue to hold until provision in that behalf is made by or under an act of the appropriate legislature. The Assam Technical Education Service Rules 1981. Another statutory rule under Article 309 of the Constitution regulates the recruitment and condition of service of the persons appointed to the Assam Technical Education Service. That includes the post of assistant professor, engineering colleges. Section 7 of the said 1981 rule, sorry, section 7, rule 7. The said 1981 provides for A's for direct recruitment. So, Bra, go ahead, take your seat.
Yes, ma'am.
Which provides that the candidate for direct recruitment to a cadre of the service shall be within the following age limits, comma, the 1st January of the year of recruitment, comma, with relaxation in case of candidates belonging to special categories like scheduled caste, comma, scheduled tribes, and any other category as laid down by the government. As per the said Rule 7, for a post of assistant professor in engineering colleges, the minimum age limit is 21 years and maximum is 38 years. The 1st January of the year of recruitment. Rule 24, 28. The said 1981 rules provides for relaxation. Which reads as follows. where the government is satisfied that the operation of any of these rules causes undue hardship in any particular case, it may dispense with or relax the requirement of that rule to such an extent and subject to such conditions as it may consider necessary for dealing with the case in a just and equitable manner. Provided that the case of any person shall not be dealt with in any manner less favorable to him than that provided in these rules. This is the last date of filing application.
My lord, 13th of March was the last date on at page number 33, my lord. But I have been informed today morning at page 33, my lord, at paragraph number HI, the last date of submission of online application form requisite fees is 13/3/2023. But today morning I have been informed that they have notified it has been extended till 28, 20/03/2023 till next Monday, my lord. A 1 week time has been extended.
Why you have come so late?
My lord, I have, my lord, this notification was issued on 21. My lord, I have filed the first representation of 2/3, my lord. And I have filed it on 3/3 before this honorable court, my lord.
Mr. Overaged, specific instruction, counsel to the petitioner on specific instructions submitted that the chairman of the Assembly Service Recruitment Board by Corrigendum have now extended the date of filing application for the post of assistant professor in Government Engineering College of Assam, advertised on 21/02/2023 up to
20, my lord, 20/03/2023. I can provide the details of the notification also, my lord.
(20/03/2023). Considering the efforts, the petitioner is directed to submit a certified copy of this order and a copy of this petition, including the annexes appeared thereto, and a copy of his representation dated 02/03/2023 before the principal secretary government of Assam in the Higher Education Department on or before 14th obtaining necessary acknowledgement from the said authority in that regard. In the event of filing such application, such listing by the petitioner within the time so specified, respondent number 1, Principal City Government of Assam, the Higher Education Technical Department, shall dispose of the such representation of the petitioner on or before 18th of March, intimating the petitioner about the outcome of his petition regarding relaxation of his in accordance with law. The above observation, this petition stands disposed of.
My lord has disposed of my request. I am deeply obliged. My lord may retain that copy, my lord. I have an extra copy, my lord.
It's a certified copy.
I'm deeply obliged.
May I please, your lordship?
Yes, Mr.
My lord. My lord, the matter relates, the petitioner, my lord, had been appointed as a district program officer, my lord, in the department of the Sarva Shiksha Abhijan mission. My lord, I was appointed way back. My lord, may be pleased to find my initial appointment. Is that, my lord, the page 34, my lord, was appointed on 15th of September 2009. And my lord, in the same capacity, my lord, I had been continuing. And time to time, my lord, transfer order has also been issued. And of late, my lord, while I was, my lord, continuing in the same capacity at Dhubri, my lord, under the district mission coordinator Dhubri, my lord, I was, my lord, fall in a trap, my lord, created by one of the teacher. That, my lord, a case had been registered against me following an FIR. My lord, may be pleased to find the FIR, my lord. I have annexed at page 53, my lord. That allegation was, my lord, at page 53 is the translated copy, my lord, and the vernacular is also available. My lord, may be pleased to find the vernacular, my lord, is at page 58. An allegation of some bribe, my lord, I have searched from that particular teacher. And accordingly, my lord, this case had been investigated by the Chief Minister's Special Vigilance Cell. And my lord, I was arrested. Now, my lord, after the arrest, after a few days detention, my lord, I had been allowed to go on bail by the learned special judge, my lord, at Kamrup, Guwahati. My lord, my bail order may be pleased to find at page 68, my lord. With certain condition, my lord, at page 70, I had been allowed to go on bail. Now, my lord, immediately after the bail, I had been also served with a so-called notice, my lord, by the mission director, my lord. That so-called notice I have annexed, my lord. My lord may be pleased to find is at page 66, my lord, annex 13. Now, my lord, responding to this so-cause, my lord, I did also reply. My reply had also been furnished at page 66 is the so-cause, my lord. Now, my lord, my limited grievance is that after the so-cause, my lord, or the criminal case which had been pending, no any departmental proceeding or no suspension, my lord, nothing has been effected. And on the other hand, my lord, I have also not been allowed to join in my, my lord, service. And thereafter, my lord, I have made
SSA, Mr. Assistant, anyone, Mr. Gogoi or Mr. Chaudhary, whoever is there.
My lord, one thing is that, my lord, they had passed an order, my lord. This order is relevant for the case, my lord. That's why I have annexed. My lord, may be pleased to find an order they have issued, my lord, wherein they have said that for the purpose of departmental action or the, my lord, departmental proceeding for these categories of employees, my lord, they will follow the spirit of the Assam Services Discipline and Appeal Rules 1964, my lord. There is a specific order the SSA has passed, my lord. That order, my lord, may be pleased to find at page 44, my lord. May I read, my lord? This order at page 44, annexure 7, save as otherwise expressly provide in service regulations and financial regulation 2003 of the Assam Sarva Shiksha Abhijan Mission. It is hereby notified that the spirit of the rules and procedure as prescribed under the Assam Services Discipline and Appeal Rules 1964, followed by the government of Assam for the inquiry, departmental proceeding, award of punishment, appeal, etc., shall be followed by the Assam Sarva Shiksha Abhijan Mission as and when any inquiry or the departmental proceeding are required to be conducted in respect of any employee, contractual or otherwise, employed under the Assam Sarva Shiksha Abhijan Mission. So, my lord, this notification was issued in the year 2015, my lord, 14/8/2015. Now, my lord, till date, my lord, admittedly, my lord, I had been implicated in a criminal case, my lord, and I was behind the bar
my lord, for more than 48 hours. So, my lord, obviously in application of the rule 6 sub rule 2 of the 1964 rule, my lord, I had been placed under the, my lord, deemed suspension, although no any suspension order has yet been issued. So, my lord, one of the contention is that, my lord, once I had been placed under the deemed suspension, my lord, then I am at least entitled to the subsistence allowance under the fundamental rule 54B, my lord. That provision, my lord, I have been deprived of. Now, my lord, I have a family and I am 50 years of age. Till date, my lord, I am without any, my lord, penny, and I cannot go to any other job also, my lord. Now, my lord, the condition of the petitioner is very pathetic, my lord. 2 school-going children are also there, my lord. My lord, the department is, my lord, is enough empowered, my lord. They can proceed with the departmental proceeding or can take a decision also, my lord. But nothing has been done. I am hanging, my lord.
Okay, we'll take it after some time. Let's
Mal.
move on to the assessment. Whatever still it is.
My lord, my friend has my lord, appeared, my lord, for assessing. Yes,
Man, he was on contractual service with you.
Lord. Suspension for there is no order of suspension.
In a CBPS case, he was arrested, in custody, support was issued.
My lord.
And you have a copy of the reputation, Mr. Nair?
Yes, Lordship.
Please come to page number 78. So some proceeding is on.
It's
going
mal,
on,
mal.
right?
Yes,
So, Mr. Nair, just let us know in the next week what is the stage. Now, petitioner is under suspension for a long period and the proceeding is going on. So he is seeking that he should be allowed to join. But the matter under the, since it is a SLPS case, it's going on, it will take some time. And since the university is proceeding against him, let us know the present status.
Lord. Next week, Lord.
Next week. Are you paying him any substantial allowance?
No.
That
instruction,
because he is a
no.
contractual employee.
Lord.
It's not a regular employee.
Lord, sir.
Allowed him to continue for long, so he's continuing.
Lord.
Right. So now, during such suspension period, if the contract has not been extended or whatever, you know better as the employer.
Lord, sir. But my lord, they follow this 64 rules. my
There
lord.
is another
Notification.
provision,
That
which
instruction.
is number 54, 43. Sorry, not 43, 44.
My lord, it is a page
44.
My lord.
Originally the 45, 46, but 44 uses it's a
Type copy, my
copy.
My lord.
Where you say that Assam Service Disciplinary Rules is applicable. Tell us on the next week.
Well, please, my lord, if some subsistence is given, I can survive. My lord.
We'll make it.
My lord.
Or Mr. Air, Council hearing for the petition. And Mr. P. Bora, standing counsel, Department of School Education.
Next to
For the corresponding numbers 1,
52.
only 1.
My lord.
Also heard, you are also in finance?
Yes, sir.
Also heard Mr. Pina, extending council finance. You will appear for SSA?
Yes, not my friend's name can be recorded.
And Mr. B. Chaudhary, standing council SSA for the respond numbers 3 and 4.
Inquiry, departmental proceeding, whether any subsistence allowance has been paid or not. And penalty of the contract.
Petitioner is serving as a district program officer under the SSA Assam on contractual basis. while he was serving as
district program officer মানে Dhubri, India.
while serving as a district program officer at the Delhi, he was program officer within the STB. On the basis of an FIR, lost by one education volunteer in anti-corruption bureau within the ACB. Police station case number 33/2022. It was arrested
Definitely not.
on 27/08/2022 under section 7 small a of the Prevention of Corruption Act 1988 in a trap case. And later he was released on bail by the special court, London Special Court on 21/09/2022 with certain conditions. The respondent SSA on 16/09/2022 issued show cause notice to the petitioner, to which he filed his reply. On 23/09/2022. Though he is still under suspension, but the respondent authorities are yet to provide, respondent authorities in the SSA is yet to provide him you have already retained
My lord.
any subsistence allowance during a suspension period. Hence, this writ petition by the petitioner, praying amongst others to set aside the so cause notice that at 16/09/2022 and to allow him to join and continue as a district program officer STSS at Dhubri. From the annexes appended, there is a petition prepared by the petitioner. There is saying that the respondent SSA by communication dated 6/10/2022 asked the petitioner to appear before the authorities of the SSA on 11/10/2022 for hearing. Also considering this matter when 20th or this week itself, next week itself. Okay, on 20th 20/03/2022. Okay, on 21st. Enabling the respondents SSA Assam to apprise the court about the present status of the hearing of the petitioner pertaining to his arrest in connection with said DCBPS case number such and such, as well as the so cause notice that at 16/09/2022 issued to him by the
Not second thing, lots of whether the contractual employees are entitled to any.
You will say.
Lots.
The respondent does also select, shall apprise, and the said that shall apprise the court whether petitioner has been paid any substantial allowance during his suspension period or not, as per his entitlement.
If entitled.
Look, there is
As
an,
per his entitlement.
there is another order, my lord, I have annexed. They have said that FR and SR is applicable. It's their stand. One.
Mr. Chaudhary, find out. Yes.
Maybe your lordship. The petitioner before your lordship is an assistant professor of a provincialized college. He has been selected and nominated as the president of the SMDC of Jafargarh Higher Secondary School. Your lordship may kindly see page number 49. The affidavit filed by the respondent number 5, the principal. And is it has been paid?
Just a minute, please take this.
Come on.
Mr. Sisti.
Yes.
Instruction.
No, sorry, Lordship, I have not received any instruction. But the impugn order that was issued, Lordship, as per the approval of the Deputy Commissioner, Provincial, Lordship. That annexes 7, page 35.
First notification, page number 25. By which the present petitioner was selected and nominated. Page 25, with the approval of the Deputy Commissioner. Starting from page 24. And the impugn notification has come within less than 3 months of the first notification. Without showing any ground, without giving any reason thereof.
Matter pertains to selection and recommendation of the SO number 6 as the president of the SMBC of Zafargarh Extended Higher Secondary School, Borai Gram, District Karimganj. Recommending as such and such as the president of the school, SMBC of the school, by the inspector of schools Karimganj from 0 to 09/2022, replacing the petition. Service of notice is complete on all the respondents. Pardon, Mr. Rear of the petitioner. Mr. SMB assistant standing counsel.
1 to 3.
For respondent numbers 1 to 3. MSP does movement plus some for the respondent number 4. And MS as does Gupta learned counsel for the respondent numbers 5 and 6. On the next it fixed. The Deputy Commissioner Karimganj and the Inspector of Schools Karimganj shall place the relevant records in an original regarding approval and recommendation of the names of the president and vice president of the SMBC of Zafargarh Extended Higher Secondary School. List of 27th. So make it 28 of March.
Private respondent number 5 and 6, my lord, they have already filed affidavit.
The copy of this order to Mr. Sisk.
Please, your lordships. My lord, I have filed the interlocutory application, my lord, and I have been made as respondent number 7 in the instant petition. My lord, my nomination to the post of the president of SMBC was challenged, my lord, basically on the 2 grounds. Number 1, my lord, my name has not been appeared in the panel list.
You have put a respondent number 10 applicant.
Applicant.
Mr. Das, are you there? Who is there? Mr. SK Das?
Number 6, Headmaster of the school.
But read petitioner? Pramod Bora. Who is appearing?
22.
These are 82, not the 54, not the supplement.
Not 20. Okay. Mr. Sharma, you are appearing for whom? Who is for the repetition? In the morning, someone made him mention, I think.
Yes, my lord.
Yes.
I have seen him. My lord. He is waiting.
Hmm?
No, I see it.
Oh, কিন্তু হেৰি কৰা নাছিল ন? Consent দিয়া নাছিল। Mr. Sisti, any information? Because main order was of course January.
Yes, sir.
Mr.
One
Sharma, you are
instruction,
appearing for the
one-
headmaster.
Yes. One parawise comment I have received from the inspector of school lordship.
Just pass on. Mr. Sharma, as a headmaster, what you have to say? Whether name of the respondent number 7 was communicated.
My lord, I have not sent the name of respondent number 7. My lord. As per instruction from received from the inspector of school, page 15. He instructed me to send the name of names of panels of 3 names. And accordingly, I have sent the names of the petitioner and other 3, page 18.
Now, after holding any such meeting or simply as
No.
you like somebody you have forwarded? On what basis you have forwarded names? After holding a
Consultation.
general meeting or just simply because
No,
you
my
know
lord.
them?
No, well, page 16, I have issued an advertisement
Hmm.
inviting application from the intending candidates for the post of president and vice president.
Hmm.
And accordingly, the eligible candidates at page 18, I have recommended.
Now, whether petitioner filed any application or not?
Yes, my lord.
Petitioner filed any application or not?
Regarding filing application, I have no instruction, but
how do you know these names?
Well, they have pursuant to that advertisement, page 16. They have submitted their application.
Now, whether respondent number 7 submitted his
No,
application?
no, why? His name was not recommended by the headmaster. Panel list 18, page 18. And page 19, again, the inspector of school instructed us to submit the information regarding the candidates for the post of president and vice president. I have only followed the instruction given by the inspector of school. I have not recommended or not changed the name of private testing.
And Madras calling back the same lordship. Again, lordship, my lordship said that I have to wait for 5 minutes. My matter will be called again, lordship.
Please go.
I will not.
Mr. Sisti.
This is the problem of that notification 2021. And that is causing all this problem. The deputy commissioner, director, inspectors.
Pointed it up to your register, to the secretary.
Yes, yesterday we had. And that notification is no one is challenging.
Not necessary. We are asking for the judgment. Mr. Gugoi is not giving us judgment. He is reluctant.
Notification. It is procedural. Notification to supervision. It free provision.
The records are with you.
Oh,
You have
record-
written
Of this case, no.
that those records.
Yes, yes. Yes.
If it is with you,
Yes.
we'll fix this matter on Monday because please come to page number. The affidavit has been filed by the respondent number 7.
Yes.
And in the affidavit, you come to page number
No.
Annex B. That is a page, internal page, because here it is continuation.
This
41.
is notification, Lordship.
That's right, notification. Now, just read it slowly.
Yes. Notification dated 27 October 2021. Number so and so, in partial modification of the guidelines for constitution of school management and development committee issued by government notification number so and so dated 24/6/2016 and letter number so and so dated 5/4/2017. The deputy commissioner is hereby empowered to select the president and vice president of school management and development committee
of an educational institution of the concerned district with approval of guardian minister.
Now, this is the deputy commissioner
Is empowered
to select the president
and vice president.
vice president of the school management development of an educational institution of the concerned district with the
With approval of guardian
minister.
Yes, sir.
Now, please come to page number 39.
So the 2016 notification.
Huh.
Yes.
If you see the 39,
Yes, the procedure, the selection process of president and vice president. The inspector of schools, after consultation with the principal of the headmaster and local people, will forward two names of to the director, secondary education Assam, for each president and vice president, with a recommendation of the deputy commissioner within a period of 30 days. After considering the names of directors, director secondary education Assam will provide the list to the government with his comment for selecting single name after comparing data of both the candidates, and then government will approve the committee. This is the earlier procedure.
now
This is the procedure. Yes.
So what is changed? If I rightly remember from the reading of that particular material of that file,
Yes.
it is quite cumbersome because first of all, it has to be forwarded to the director of secondary education.
Yes.
Then the director of secondary education again to the government for approval.
Yes, no, yes.
After that, first of all, it will go to the
Deputy commissioner for recommendation.
Deputy commissioner will approve it, then it will go to the director of
Director.
secondary.
Yes, Lord.
Director to the government.
Yes,
And government will return it after the approval.
Yes,
Then the
Lord.
appointment.
Yes,
So
Lord.
this cumbersome process, to simplify it,
Yes.
it was given to the
Deputy commissioner.
recommendation was given to the respective deputy commissioner of the district concerned will do the needful in place of the director of secondary education Assam
And the government. Yes.
Now the minister notice clear that it should be as per the approval of the director, the concerned guardian minister.
Yes.
So instead of the director of secondary education or
Government.
it should be the consultation with the
Guardian minister. Yes.
other parts not disturbed.
Yes.
But if you read this particular notification as a whole,
Yes.
you will see the process has been changed.
Yes.
Now the deputy commissioner is empowered to select.
Yes.
So what names, nothing is there, you can select anybody and can forward, but that is not the issue. You read the file. That is why we are asking you to produce the file if you have, because we have written it to you.
Yes.
So if you can give it to us, if it is with you, you can give it to us by Monday.
I will check it, Lordship. If I have not sent it back, Lordship.
I think it was reported by the other court. That's why we gave it to you.
Yes, yes, yes. Yes, that is here with us.
That
Lordship.
is, it has to
Yes.
give it to us by Tuesday.
Yes.
If not on Monday,
Yes, yes.
we'll clarify.
Yes.
Right?
Yes.
We keep that paralyzed communication.
Yes.
Otherwise.
My lord, may I pray for fixing it on 15th of
15 is a motion day, so we have it on 14 Tuesday.
14, my lord, I have problem, my lord. My word is appearing in the high secondary examination.
On 15th.
16 months.
16 also examination is there.
Then Monday.
That is my word.
Monday.
And he is army school, Naring.
Monday, 13.
13.
13.
13.
Possible. In case I say number. Huh? Monday not. Probably something will be there again.
Maybe 14, my lord.
14.
14. Any difficulty?
14, my lord.
Mr. Sisti?
Yes, I'll.
List on Sisti?
Yes.
Sorry, list on 14, enabling Mr. Sisti from submit of the
Lordship, this I is for vacating of the interim order dated 2/9/2021, wherein the provincialization has been stopped of the respondent number 8, the respondent number 6, that is the applicant, Lordship. Lordship, first of all, this writ petition is premature, Your Lordship. Impugn order is at page 24 of the application, Lordship. Operative part is at page 26, your Lordship.
Whether your name was recommended by the district scrutiny committee.
Lordship, it is in a writ petition, Lordship. Kindly peruse page 68, your Lordship, of the writ petition. RTI information is there, Lordship, from the State Public Information Officer, Elementary Education, Assam, Lordship.
Which page?
Page 68 of the writ petition, your Lordship. Page 68. Page 68.1, Lordship. The recommended and non-recommended teaching staff at Rajdwar Simantawati ME School under Lakhimpur district as received from the district elementary education officer. Lakhimpur is enclosed as Annexure A1. In page 69, Lordship, the names are there, Lordship. Serial number 80, Rajdwar Simantawati ME School. Number 1, Nanda Bora. Number 2, Sangita Bora. Number 3, Harka Bahadur Subba. AST, that is Hindi teacher, your Lordship. I am Harka Bahadur Subba.
Now, whether the state level scrutiny committee has given approval or not. Whether the state level scrutiny committee recommended.
Probably the state level scrutiny committee has recommended. That's why my service has been provincialized.
Where is the order of provincialization?
Order of provincialization is page 23, Annexure G of the IL, Lordship. Page 23 of the IL, Lordship. Lordship, in a similarly situated case, the Lordship was passed to. The Lordship was pleased to pass an order.
Please take your seats. Okay. So, who is appearing for the statement?
My lord.
On to 52. Got it?
My lord, one.
Only page 52 of the repetition.
My lord.
Now, you see that is at which year 2011-12.
My lord.
Top.
My lord.
See the respondent number 4.
My lord.
Nanda Bora.
My lord.
Then you will see classes taught.
Main subject all.
Main subject is
One, all subject.
That is all subject. And classes taught is 2.
Two, my lord,
Languages.
language.
Now the petitioner.
Petitioner, 3, my lord.
No,
And
classes taught is 2.
2, my lord. Language,
Okay.
my lord.
Then main subject is 3.
3
Mathematics.
mathematics.
Then remaining all language. Krishna
Language.
Gopal Das language.
2, my lord.
Dulal Burwa 7.
Dulal Burwa, 7, my
That
lord.
is science.
Science, my lord.
Now 5. The respondent number 6 here is the language.
My lord.
Right.
Here, social science is not there, my lord. For environmental science is not there. No one is teaching, my lord, environmental science. Go to environmental studies. 3.
So in that case, whether case of the respondent number 6 could have been provincialized or that of the Krishna Gopal Das.
Two, language.
Any language.
My lord.
Why Haro Bahadur Subba? There are people senior to him.
Yes, Krishna Gopal Das. My lord. My lord, he is, but date of joining 2001, my lord, Krishna Gopal Das. Only Nanda Bora and my lord Harka Bahadur Subba of 1992, date of joining. There and Pramod Bora of 1992.
91.
92.
92.
The main subject 0 the passage. Science station 2008.
Mr. Esquitas, Learned Counsel, appearing for the petition.
Also, I have some submission. The petitioner also hearing also, he is the senior most and the founder teacher also. He was appointed in 1191 and I have also annexed my appointment order. And your lordship has already seen page 69. In that order also, lordship, my name is reflected in the non-recommended list, lordship. In the column, lordship, 1193. Assamese and English. And the persons, 3 persons who have been provincialized, Nanda Bora, he is the headmaster, Sangita Bora is his wife, and Harka Bahadur Subba, his appointment is subsequent to myself, lordship. And there is another additional thing, lordship, that Harka Bahadur Subba, he has obtained his higher secondary examination only in the year 2018.
No, your lordship.
And as per the provincialization order, lordship, he must acquire, the appointee must acquire the requisite qualification before the date of joining in the school. And date of joining must be on or before 31/12/2010.
In this regard, may I submit, lordship?
Come back to you. Anything else, Mr. Das?
Lordship, so I have been illegally deprived being the founder teacher, and this honorable court being prima facie satisfied has passed the interim order cancelling, stopping his salary.
Yes, what do you want?
Lordship, no, lordship, this is 2018, this mark sheet is for betterment scheme, lordship. He has passed high secondary in 1993, lordship.
Where is it?
Lordship, Annexure B, page 15, lordship. Appeared under improvement scheme, lordship. This appeared under improvement in the mark sheet itself, it is reflected, lordship.
Lordship, the mark sheet shows that it is 2018 examination.
Appeared under improvement scheme, lordship.
There is nothing like appear on the improvement. So, no, I got none. Anyways, lordship, the petitioner is senior to the private respondent.
Mr. P. Border, Mr. P. Border, Standing Counsel, Department of School Education. What are respondent numbers? Respondent number 1, 2, 3, 4, 6. Mr. P. Border, respondent number 6. And MSD Das Bora. PNAC, Standing Council, SSA Assam, respondent number 7. Matter pertains to provincialization of service of the petitioner. No, very good. Petitioner is agreeing as the respondent authorities in the elementary education department of the state. Provincialize the service of the respondent number 6 as a tutor.
Rajduar Simantawati.
In Rajdhar Anuchitita Lower Primary School, the Behpura Education Block of Lakhimpur District under the provisions of 2017. Disregarding the better claim of the petition. Tutor by order number EPD-16 of the provincialization of PK UP upper primary within bracket Act 2017 bracket 2 public 2021 public 4500 data 0502 2021 issued by the Director of Education Assam. In terms of the approval given by the state government in the limited department. It is submitted by the petitioner that after obtaining his passed his higher secondary examination, the managing committee of Razdwar Simotavoti ME School, during its success stage, 15/12/1992, appointed him as an assistant teacher of the same school, pursuant to which he joined the same school on 1st January 1993. He has also obtained diploma in elementary education from Basic Training Center within bracket Azad, the Azad, Public Lakhimpur, year 2019. The response number 6. The Hindi teacher joined the site this school on 15/12/1992. And
So it is 23/4/1994 as per the provincialization order. 23/4/1994, page 69.
Actually, Lordship, 23/4/1993 it should be, Lordship. 23/4/1993, Lordship.
1993. Letter and the petition. The response number 5, 6, not 5, also passed his, also obtained his diploma in elementary education in year 2019 from Basic Training Center, Azad. It is submitted by the petitioner that the response number 4 as well as response number 4, headmaster of the same such and such. Response number 6 are the language teachers of the same school. Whereas response number 4 was teaching English and the response number 6 was teaching Hindi. And as per the provisions of Rule 3(1) Roman 11 2017 notes, Section 3(1) Roman 11. Only one language teacher, service of only one language teacher can be provincialized. The court accordingly, while issuing notice to the respondents on 02/09/2021, state the provincialization of the response number 6, which is junior to response number 4. And further, stopped the salary payable to the response number 6. Order 103/2020. It is seen from the petition itself that the petitioner through RTI obtained necessary information that the district scrutiny committee Lakhimpur recommended the name of the response number 5, 6, and 7 for provincial of their services, which was accordingly approved by the state level selection committee, on the basis of which response number 4, 5, and 6, the service of response number 4, 5, 6 are provincialized. We have seen the provincialization order of the service of response number 4 and 5 from the annexes appended to this petition, and that of response number 6 from the annex from the annexes appended by the petition. From the perusal of dice data annexed by the petition, on the basis of said recommendation of the district scrutiny DSC Lakhimpur, the state level selection committee recommended again name of the response number 4, 5, and 6. The approval pursuant to which the director of Indian business sum by order date 05/02/2021 appointed the petitioner, the respondent numbers 5, 6, 4, 5, and 6 as tutors. From the dice data we are 2011-12, the said school such and such annexed by the petitioner, it can be seen the petitioner used to teach mathematics to its students, whereas response number 4 is to teach language, English language, and response number 6. earlier petition filed, the petitioner filed an appeal before the state level scrutiny committee. So just to get no date, nothing. On 13/04/2021 to mathematics. Yes, state level scrutiny committee represented by the director of eligibility. Against the provincialization, that is 05/02/2021 of the respondent number 6. Section 19 of the 6 census relates to suits and proceedings. Section 19, Section 217X provides that such. The case in hand, it is seen that the district scrutiny committee did not recommend the name of the petitioner for provincial attorney service. Further, district level scrutiny committee also district level scrutiny committee further approved the said recommendation of the district scrutiny committee Lakhimpur and recommended the name of the respondent number 456 for provincial attorney service under the provisions of 2017 Act, which accordingly was approved pursuant to which the director of elementary education Assam on 05/02/2021 appointed respondent number 4, 5, and 6 as tutors in such and such school. Considering the above and finding the petitioner senior to the respondent number 6 from the date of from the lies that are 2011-12 the school in question annexed by the petition as well as the
Can I submit one thing to the Lordship? Lordship appeal, they have not prepared the appeal before the government, Lordship.
We have filed the appeal.
Lordship, only state level scrutiny committee, they have filed the appeal, Lordship.
We have filed it.
Against any recommendation of the state level scrutiny committee, the appeal should be preferred to the government, Lordship. And this,
the petitioner is directed to approve the concerned educational tribunal for provincializing the police. Which of is the respondent number 6 on or before 27th of March. Okay, on or before 30th of March. The certified copy of this order. In the event of filing such appeal before the concerned education tribunal, the authorities concerned, after hearing the petitioner, the respondent number 6, and on perusal of the relevant records, eligibility of the restaurant number. Petitioner has a restaurant number 6. Provincial of their services under the provisions of say 2017. Restaurant number, petitioner and the restaurant number 6. Records in original. With all observation of this petition stands disclosed. However, it is made clear. Enabling the petitioner to approach the concerned education tribunal. The provincialization order of the restaurant number 6. It is 050 to 2021 issued by the director of the limited education. Shall remain suspended. Thereafter, on consideration of the petition, prayer of the petitioner for such stay of the provincialization by the concerned education tribunal, will have the effect of the provincialization of the restaurant number 6. However, it is made clear the concerned educational tribunal shall pass its revision order without being influenced by any such observation made in this order noted above.
What is the interim order?
Only up to 30th, you make a prayer for stay before the tribunal. Every order must this IAB such and such being in substance.
My appeal is also pending before the.
That will have more
Process. So we will approach the education tribunal.
Thing is this, your name was not recommended.
No, sir. Because of the resolution of the.
Don't know. And secondly, the state level scrutiny committee also approved the recommendation.
No, sir. Without any verification.
There is a judgment somewhere passed in one point of time earlier, only 2017 Act came into force. I'm not getting that order. Who passed that order? One of the coordinate bench passed that order. Clarified in that matter. The district scrutiny committee doesn't recommend a name.
Gotcha.
It might be by what's the order? So you have to approach the tribunal.
Gotcha.
Here is a case not recommended by the tribunal.
Gotcha.
Right? It's correct that at a certain point of time your appeal was before the corrected India before the state level scrutiny committee because
Gotcha.
against the decision of the district scrutiny committee.
Gotcha.
But there is nothing as such that order you have passed, that appeal that you have preferred after the order passed by the state level scrutiny committee.
After the provincialization order.
It has no effect. Yes. Because state level scrutiny committee recommended the name of the restaurant number 6.
Gotcha.
It's a division bench order or something, so I'm not getting it. Let you know. Some other orders will clarify.
Gotcha. So, Lordship, that provincialization order will remain suspended
till 30th.
Till 30th of
March.
March.
You prefer appeal along with the step.
Gotcha. Obliged.
Obliged.
Well, item 34 and 35, madam. 34 and 35.
34, there is an interim protection, madam, till today, madam.
My lord.
Item
Well,
30.
date may be there is the urgency, my lord. Then after the
We have already-
session, my lord,
we have
that
already-
is that may be fixed on 16th of March, my lord.
16, I have some
16.
difficulty. Can it be on 23rd, madam?
21st.
34 and 35, my lord. Order dated 8/2/2023 and 22/2/2023. That is the last order. 22/2/2023.
But these cases are still pending.
Yes, my lord.
What happened? They allowed to attend the class?
They allowed me to resume the class and they gave me a fresh transfer certificate, my lord. Now that also I have come before your lordship, my lord, and lordship have protected me, my lord. That is stayed, my lord, by this honorable court. In fact, my lord, she has filed an affidavit and I have also filed my reply today.
Yes, ma'am.
Pleadings are otherwise complete. Repeated harassment, my lord. Repeatedly harassed.
Can we fix, madam? As early as possible.
21st.
So 21st, I have some difficulty. Tell me 23rd, my lord.
21st is okay.
23rd.
Maybe 16 also.
Let it be on 23rd, my lord.
28/20.
22.
20, madam.
Obliged, deeply obliged.
My lord, item number 26.
My lord, interim may continue.
15 may be given, 15.
My lord, interim may continue.
We'll see.